Hey, good morning and welcome back to the cafe. Great to see you all today, guys. Today we are coming live to the University of Idaho Murders Brian Koberger pretrial conference hearing today. We're going to be running live here shortly, 11 a.m. Eastern time. I believe it's 9 a.m. Central. So Mama Bear is joining me, from my understanding, I do believe. So please make sure when you come in to click the link on her side of things as well. With that being said, you know where we're at with this. Let's do this thing. All right. Good morning, peeps. How are ya? Good morning, Mama Bear. How are you?
Hello, I'm good.
Thank you for joining me today. Surprise, 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 surprise. And welcome, everybody, to the next edition of What the Hell's Going On in Idaho. Today is the Brian Koberger pre-trial conference hearing to start here shortly. So thank you guys for joining us for that. Appreciate you very much. I have the link set and ready to go. We'll see how this goes. I don't know how long it's going to be, but I will be here from start to finish as long as I can help myself. I don't know if Mama Bear will be, but 100% I will stay at. I don't know. That's a good question. Probably not. I didn't even realize that. Is it giving you an option, Bear?
No, and that's why I asked.
That's probably why. Sorry.
It's okay.
That's going to run out too.
We'll just hang out today then.
It's all right. My apologies. You guys can still hop over, hit Mama Bear's like, guys, please, if you will, and like her channel, subscribe if you have not, guys. The bills are coming due. My StreamYard thing is coming up again, so now I have to use their free service, so we can't do it the way we want to. It is what it is. It happens every so often. So who do we have in here this morning? Miss Wisdom, welcome back to you. Alicia J, great to see you. Sassy Cassie, thank you for joining us. Yvonne Poole, Mikey's in the house with the last 24. Good to see you, Brandy B, the OG. Thank you for being here. SRBBBBB, thank you for joining us. There's Mama Bear's link right there, guys. Victoria Burgess, welcome back to you. Great to see you today. Let me see here. Social phenomena. Oh my God. Phenomenon. Jesus. I think I said it the right way that time. Phenomenon. That's a tongue twister for real. Phenomenon. I love it though. Welcome to you, Amy Conway. Buenos dias to you, Miss Lisa Wilson. Welcome, and thank you so much for that compliment. I appreciate that. We all do, because it ain't just me. It's these Blue Crew people here. They're amazing, as well as Mama Bear. I wouldn't be able to do this without any of them. Moonlit Baby, good to see you. Welcome to you as well. Come on in the door, guys. Grab a seat, get comfortable, because we don't know how long it's going to take. Please, if you will, make it a comfy one. Grab yourself full cup of Joe. And yay. Yes, by the way, guys, If we can drop Mike's link in here again. The last 24. The first show is tomorrow. I would love to see you up there, guys. I demand it. I demand it. I'm just kidding. But I we would really appreciate you guys being there to support Mikey with his first show. Please and thank you guys. Tomboy's in the house. Welcome. Good to see you. The Blue Biatches. Okay, if you call yourselves that, I'm not going to, but you can. Mikey's not. The Blue Biatches and Mikey. We'll just say it that way. How's that? There's Mama Bear's new channel name, by the way, Mysterious Minds. For those, so you guys are confused, that's Mama Bear's new channel name. Fox Rooter, welcome. Thank you for joining us today. Right there, that would be the new name, Mysterious Minds. Pretty awesome stuff too. I love it. Great name. Moved to 8 p.m. I'll repost today. Thank you, bud. Okay, Miss Molly. Good golly almighty's in the house. Singing live stream. Welcome. Good morning. Great to see you. Who is that? Steven? Maybe not. See who else we got. I hope Jesse and Eddie show up. I see Sarge did a show last night. I don't know if you guys went. For those of you that went over and supported him, I appreciate that. He's an important part of our community too, and we got to support him as well. So anybody that you guys support within our community, that I call our community, Mikey Wisdom, Sarge, Molly, all of us here, we appreciate all the support you guys give very much. Fizzy Cake. Good fizzy morning to you, and fizzy welcome. It's so fizzy nice to see you. Why am I doing that? I don't know. There's something fizzy wrong with me today.
Maybe I think your brain's a little fizzy.
I was going to say that was coming next. Thank you. See, I'm a little fizzy brained. Fizzle, fizzy. There's Miss Wisdom's channel. Thank you guys so much for posting that. Please go check out Miss Wisdom's channel. She does some amazing things for the missing, as well as the indigenous missing, which is very important because a lot of people don't do that and cover that. So please go over and support her channel and show some love over there, guys. She really needs it. We need to grow her as well and get her moving. She does amazing things, as well as the lovely and amazing and talented Miss Molly Drake. There's her link to her channel. She is the channel videographer here and does all the amazing things for our intros and our outros and our musics and all that fun stuff. Everybody has a thing they do here, guys, and I wouldn't exist without any of these people. I promise you that. So thank you, Molly, for everything you do. Guys, please go support her channel and show some love over there. She does some really, really amazing things. She's very talented. Yes, missing and news, Miss Wisdom says. Thank you. Well, I love what Wisdom does for indigenous missing because hardly anybody touches that, guys, and it's so important that it gets seen. Eddie's in the house. One maiden nut. There he is. Good to see you, buddy. Yes, and of course we have the lovely Miss Brandy, the OG. She does our TikTok. Please go check that out as well. Wisdom also runs our Facebook page here, guys, and does an amazing job there. I told you, everybody does something. Miss Cassie, she runs the merchandise shop and takes care of all that stuff over there. Mama Bear does everything that she does, which is everything else. And all the other mods do some amazing things too. Everybody does something. I just sit here and run my mouth. Jesus, that sounds so good to say that out loud, doesn't it? And research and drive them insane. There's our Miss Cassie and the link to the merch shop. She's put some really cool stuff in there recently. Please go check it out, guys, if you will. Turquoise alert just passed in Arizona. Thank you. That's a new one. Turquoise alert. That's awesome. Thank you so much, Wisdom, for that. I know what that means. That's for indigenous natives. That's awesome. That is absolutely amazing. Thanks for telling us that, Wisdom. Yeah, SRB and Alicia are the and Brandy are the head knockers. That's what they do. Not so much SRB. She's too nice for the head knocking, but Alicia and Brandy will knock your heads together real quick. I'll tell you that much. That's for damn sure. And Mikey just comes in and looks pretty. I'm just kidding. I'm just kidding. I'm just kidding. You know I love you, bro. Shared that in the members chat the other day. But thank you, Miss Alicia. Well, it's good to see you singing live stream. Thank you for being here. And of course, the tomboy, one of our reporters in the field, as I call it. She's always bringing me stuff left and right. Her and Miss Tandy. I wish Miss Tandy was able to be here today. Wait, it's Friday. It's Thursday. She's not off on Fridays. She's gonna miss this trial. That sucks. Or this hearing. Kearney, welcome. Good to see you. Yeah. How are you feeling today, Bear?
Good.
No headaches today or anything?
Nope.
Good. You get some sleep?
Yeah.
Good. I slept good too. Tish Rhino, good morning. Thank you for joining us today. Hope you're doing well. By the way, welcome to all the new meatballs. Adrian, good to see you. Being silly. Hey. I don't know what else to do, Mike. Excuse me. Alicia smacks people for us. Yes, she does. Yeah, Alicia smacks them. Brandy hits him over the head. It is what it is. SRB just very kindly smiles at everybody, and that's what she does. Everybody's got a place and a thing. So glad to see you here, Molly. 2-3 days in a row. We've missed you greatly. It's great to have you back here. What's at stake today for the hearing? Well, Kent, they're saying that this is the pretrial conference hearing. So I have a feeling, I believe that the alternate suspect thing is going to come out with this, this is what I'm really curious about. This is the thing I've been anticipating for from the beginning, I think, truly. Third party culprit. So I heard Hitler is ignoring the we'll see. We'll see. Hitler's been ignoring a whole lot of stuff. I'm sure I'm going to be swearing today, so be prepared right out of the gate. I'm going to tell you guys. You're probably going to hear me say some bad words today. So I'll just do this now.
Trigger warning. Content may include sensitive or violent content not suitable for all viewers. Feel free to step out if needed.
All right, guys, let me get this loaded in here. Where did it go? I just had it up here. Of course, they're running late, as they always do. And that's just in case. Oh, shit. Come on, Dago. Get yourself together here today already. Keys. Guys, I've been up and showered and shaved and all that other fun stuff. Went to the doctors and everything, and here we are. Media's offline still. Yeah, I'm real curious to see how Judge Hippler acts today. How are they getting wet? That's a great question, Tish. It really is. It really is. I think we all ask that question at least once a day with this case. In the court summary, it is referred to as pretrial conference. Who can? Yeah, that's why that's what I titled it as, Eddie. But who knows? Who knows what's going to happen? We might get some big surprise today, and Cy Ray's going to be there, and he's going to tell Judge Hippler to go F himself because he called him a conspiracy. Who knows? That would be a hell of a show, wouldn't it? Wouldn't it? Hell of a lot of drama, but I doubt that's going to happen, guys. All seriousness, though. Alicia and I are. Oh, stop it, Cassie. You are not. Alicia gets our eyeballs out of the back. Yes, that happens a lot. By the way, we went through and reviewed a few of us last night in Discord the Dateline episode. Oh, Lord. For those of you that didn't watch it, guess what? You didn't miss nothing. It's a whole bunch of bullshit. A whole bunch.
Not surprised.
It was actually worse than I thought it was going to be, Mama Bear. Honest to God. You can ask SRB and Alicia. Has anyone heard if there is help? Brian's family fund. There's a isn't there a GoFundMe set up for his family right now? Already pre-pissed. That was good, Elisa. She's pre-pissed for the pre-trial.
I am not 100%, but it seems like I saw something about that.
Yeah, I think there is somewhere. If I can find a link for it, we'll throw it in for you.
Or it was a GoFundMe for Christy and Steve.
Yeah, of course. And there should be one for his family just as well. They didn't want one, though. Yvonne said, well, I understand. Yeah, we watched, Tomboy was in there with us as we watched that last night. She made that statement last night, and I have to agree with her that entire Dateline episode was completely and fully based off of Dumbledore, Bloomberg, whatever the hell his name is, his book. It's ridiculous. It's absolutely ridiculous. Miss Wisdom says, I know that an alternative suspect has to be more than just hearsay, so I want to know what yeah, agreed, ma'am, agreed. I hope it does. I hope that does play out today. I'd be real curious to see this. The entire special is based on Bloomin' Idiots book. Yeah, there you go. Bloomin' Idiots. Can you imagine the MSN twist that Brian's family had to go for me? Oh, I know. That's probably why they don't want one. Oh, for God's sake. Are you kidding me? Nope. Yeah, that would be insane, Eddie. Truly. I wonder where Jesse's at. Come on, Jesse, get in here, bro. I want your input today, too. At some point, I'll probably bring a few of you up here with us to discuss certain things in between. T2014, welcome. Good to see you. Ashley Brogden, congrats. Uh-oh. Happy birthday. Don't let me forget that, Mama Bear. After, because this is going to start any moment now. Happy birthday, Miss Ashley. Thank you for being here. All right, Tish, we'll be here. Make sure you guys wish Miss Ashley a birthday. Happy birthday. There's a GoFundMe for Maddie's family. Okay, that's good. They need to have that. The victims' families definitely deserve to be able to make sure that they can get there. Oh, Lord almighty. 63 peeps in the house. Guys, please make sure to hit that like button. Share this out. Let everybody know what we're doing today. The next excerpt of the crazy Idaho case. We love you too, Ashley. Thank you so much for being part of this community. Absolutely. I hope you have an amazing day today. And once we get through this, we'll celebrate your birthday a little bit in here as we do with everybody's. Thank you so much for joining us. Miss Lily Rose, good morning, dear. Good to see you. Thank you all for joining us today. I hope that Kara, I hope that somebody put together a GoFundMe for Kara so that if she wants to be there, she can. I think it's only fair for all of them to be able to be at that trial if they want to be. The way she was talking, I don't know that she wants to be, but I hope she has that option if she can. They might fine them for not obeying the leash. Tomboy's in full effect today. Thank you, Mikey. Moonlit baby, good morning to you. Again, hit that like button, guys, when you come through that door, please. And thank you. And please share this out. All you beautiful peeps. Great to have you here. It's supposed to start at 11:09. It is 11:09, would be 11 here. It's 11:09. They ran late last time, I think, by a few minutes, too. If I would have got in here earlier, we'd have done Ashley's birthday beforehand, but I was running like right on the line because of my doctor's appointment, so I'm sorry. There he is. There he is. Thank Lord. Good to see you, Jesse. Good morning, brother. What happened last night? And as far as what, buddy? In here, we didn't do anything for a show last night, but I was in Discord with my mods and we watched the Dateline episode, which was a joke. I saw a stream scheduled with the headline fake. Where? Not here. 9 would be 12. No, it's always been 11, Tomboy. With my logo. Where did you find that, buddy? If you have a link to it, let me know. True crime with Dago on your channel, yes. I didn't have anything scheduled last night. I don't have anything scheduled in there now. Well, besides this, I scheduled this early this morning. Yeah, it is in a different time zone. I don't know, unless somebody threw it up there. I don't know. About me, maybe. No idea, buddy. I don't know. Was there anything shown scheduled for the channel that you saw, Mama Bear, last night?
Do what?
You didn't see anything scheduled for the channel last night, right? 3:47 p.m. What?
Huh?
Did you guys have a link that you can grab to see it? I don't know. I didn't have anything scheduled. I did the morning show yesterday, and then I ended up in the Discord with my moderators, and we watched the Dateline episode just to catch up so that we know everything going on there so that we'd be prepared for this. Fake. It was titled Fake. Someone playing around, obviously. Whatever.
You know what? That might have been me.
What did you do?
I was trying to go into your StreamYard to see if I could download your intros and outros from StreamYard.
Mama Bear's trolling me now, folks.
Yep. So I bet it was me.
Okay. Did you title it Fake so that people didn't think it was a real live stream? Okay.
Probably.
Jesus. All right. Well, that's what the deal was. No, you're not crazy, buddy. All right. Well, that's the deal. Well, at least I feel better now. I was worried I had some kind of a troll doing something to me. So, all right. That might have been me playing games with my mind. Quit playing games with my heart, Mama Bear. Eddie said the imposter has been caught red-handed. Or red pod. Because she's a bear. Almost couldn't load YouTube this morning. It's probably because it's overloaded today. I will guarantee you everybody's gonna be live at the same time. Were you able to do what you were trying to do, Mama Bear? Now she's not talking to me. See? Let me try something here. Come on, Hippler. What are you guys doing in there today? 13 minutes in. Where you guys at? Makes me wonder what they're doing behind closed doors before the trial or the hearing. I'm going to check something, everybody, real quick. Hold on. I'm not gonna sing to you. Jules is live with it too. Let's see if she's got anything yet. Nope. Not a finger. Welcome, Clifton. Good to see you. Well, I appreciate you all taking the time to be here with us today and choosing to choose this channel to be with. We appreciate you very much. And that's a fact. Hitler is trying to figure out which way he wants to put his hand underneath. Yes. Yeah. Yeah. They're that was great, Lily. Yes, they're doing pre-position to see which way he's going to lean on his hand. Here we go. Here we go, everybody. Josie West, good morning and welcome. Miss Tracy, wonderful to see you. Clifton Mayo, great to have you here. Guys, please share this out again. Thank you so very much. That was great. Thank you, Lily. I needed that laugh. Summer Thunder's winning the house. Good to see you today.
No, I wasn't able to do what I was trying to do.
Oh, I'm sorry. Okay. We got 60 people, 44 likes, guys. Let's see if we can make that match. Please and thank you. It's always a pleasure to have you, Clifton. Thank you. Josie West. Good morning, Miss Charlotte. Welcome. Good to have you today. Again, share it out, everyone. We have plenty of room in the sauce today. Mama Bear went out and picked up some new pots. Her and SRB and made extra room for all these awesome meatballs to jump in there with us today to spill this sauce. And once we get rolling, I will put a link in here to have a few of you join us up here today. That way you can express your thoughts and feelings as we go through during breaks. If you would like to, Jesse, Eddie, some of our regulars. I'm curious to see how this goes down. We should run a poll today. What should we run a poll on? Absolutely my pleasure to have you, Lily. Always. I hope Judge Hippler adheres to the new courtroom decorum standards. Good point, Eddie. Good point. Guys, if you want to become a meatball, it's very easy. Click on one of these two links here that Miss SRB dropped. That one right there is quick and easy. If you're on your phone per se or a PC, it should let you jump right in. Also, this one down here is for iPhone users that I'm sorry to hear. Because sometimes it gives you a hard time. That link will take you right into it, and you can jump right on in the sauce with us if you choose to. That's fine. No worries. Welcome, Cougar 1970. All right, so that's going to be our first poll of the day. Will they bring forth the alternate suspects today? Yes, no, or unsure. Vote away, folks. Vote away. How will they bring up alter purposes poll? I did the same thing, basically. Cougar 1970, the new name. Welcome. I love seeing all these new names. We're growing amazingly, folks, and I want to thank you all for that. Every day we get a little bit larger. Appreciate you all much. Again, if you might want to double check, guys, because some people have explained to me, voiced to me. We got in my head, SRB. Anyway, what was I going to say? Make sure that if you want to be subscribed to the channel, double check it and make sure you are. Because they do unsubscribe people sometimes, I found out. So make sure that is a thing for you guys. SRB, did you set the subscriber thing? I didn't even look to see. That's what I was hoping she was going to do today. If Jesse was get him approved. Cat K, good morning. Good to see you. You did? You did. Of course you did. Why would I even ask? You always do. Thank you. Every day it's going faster. Well, maybe that's a good thing that they're late. Maybe she's presenting something to him that bring forth. Maybe it's a big deal. Who knows? Maybe they found the right person, the right suspect for this, and they're bringing him in. All right, Molly. Take your time, hun. You're good. Another poll suggestion could be, will Judge Hitler interrupt the defense? That's a given, Eddie. We know. How many times is Hitler going to interrupt Anne or any of the defense? Agreed, Clifton, agreed. Again, welcome everybody. Please make sure to hit the like button on the way through the door. I really want to get this in the algorithm today if we can, and share this out. I appreciate it. And welcome to all you beautiful peeps. Stop. What am I doing? What am I doing? Telling me to stop. What did I do now? Am I doing something wrong?
Not that I know of, but who knows? I did.
That's a big point, Eddie. Or I'm sorry, Charlotte. Saying the same thing. What did I say? I don't know what. Oh, same thing she said. We didn't get started over here as well. Oh, about it's a given. Yes, I know. You're in my head. I ain't doing it on purpose. I can't help it. Thank you so much, Charlotte. I wonder what Anne is wearing today. Is she wearing green or blue? For those of you that can't tell, I'm a huge fan of hers. I think she's an amazing attorney. And very strong and independent woman. I have a lot of respect for that. So, Aurora, welcome. Good to see you. Again, anybody that would like to, shut your mouth, Cassie. Anybody that would like to become a meatball, all you got to do is send an email over to our OG Miss Brandy B at mama350@AOL.com. Title it Discord link and state your YouTube name, please. We want to make sure we know who you are. And we'll bring you on into the Discord if you would like to join us in there. That way you can hang out with all these awesome people in this community when we're not live, too. I don't think she should have taken another don't, though. I don't know what you mean quite, Miss Tracy. I hope so. I feel like they are too, Eddie. I think Anne has had some time. You know, the last hearing.
She's trying to say shouldn't have taken on another death penalty.
I understand what you mean. I get it. I got you. Yeah, that's what she said. I see it there now. It's okay. It's not your fault. No, I can agree, but I think she did it for a reason. Like I said, guys, I don't think Anne does anything without knowing the result ahead of time. She doesn't ask a question without knowing the answer. She doesn't set forth into something without knowing the results of it. And I think she's very calculated. So I think there's a reason for that. I'm not saying there's a relation between the two cases. Okay. I think she knows what she's doing, and I trust in that too. We should have done the Discord, the Dateline thing in general. I didn't even think of it. Well, it was a last minute thought, SRB, but yeah, it was a good idea. In the future, we will do stuff like that, though. It's a good point. Welcome, Mr. Gary Heineman. Great to see you, my friend. Welcome back. Great to have you here again. Thank you, Molly, for referring Mr. Gary to us. We appreciate you, Gary. Yeah, we hadn't planned it, but for the future, that's a good idea. We can do stuff like that. It's actually something I want to do. Hitler needs to buy himself one of those neck pillows to keep. You're on one today, Lily. I love it. Yes, he does. I agree with you. The dude looks like he's like sound asleep every time, and it's like it's ridiculous. 100%. You are right, and we will be doing stuff like that for the future. It's a great plan. That's a good point too. Very good point, Alicia. I want to do other things in there too, and follow certain things that we can't do on YouTube. That's kind of the point. So yes, very good ideas. Come on, y'all. What are you guys doing today? That's the whole point. I was getting ready to say that, Charlotte, because the last hearing, Anne had just buried her mother, very sadly. And you could tell she was a little bit off. And I think she's had some time to hopefully mourn and recover a little bit, sad as it is. And she'll probably be a lot more focused and on point today. And even then, with that going on in her life, she still seemed to be very on point. That says a lot. She's an amazing attorney, in my opinion. So I know a lot of people don't care for her, and I respect that. I get it. But the way the strategies that she goes with and the things she does, the way she does things, I think is very impressive. So exactly, Alicia. I don't think so. I think he's just lazy and he's an ass. He likes to show his irritation to the world. Nobody cares. It's got one of the worst attitudes I've ever seen from a judge, and it's absolutely evident and sad. Welcome, Miss Becky. Good to see you today. They could be. She could be presenting that as far as foundation for that. You know what I mean? That could be what it's about. So we'll see. If that's the case, that would be awesome. Curmudgeon. Excellent child. I love that, Alicia. That's great. He does in some senses. His little temper tantrums and all that stuff, talking over, disrespecting, disrupting. It's just rude. Somebody brought up a statement last night or yesterday. Twisted Tales of True Crime. Wonderful to see you. I love your name. Hey, too cool to see that you guys are streaming the case. I love your channel and all. Thank you so very much. And I appreciate that so very much. I love your name. It's great to see all these new names and faces in here. Somebody brought up a point where I think they were stating that they heard, of course, everything's hearsay nowadays. You know that. And that they heard somebody was trying to get him recused, to recuse himself and or to move the venue again. If that's true, I don't see either happening, but you never know. And they're stating that the reason why they were trying to get him recuse himself. Sorry, I can't talk today. Was because he shows bias, which he shouldn't. There's a few things that the man has done as a judge you shouldn't do. That was really surprising to me thus far. So we'll see. We'll see if he straightens up. I don't know. Good morning, Bemmy Rose. Good to see you today. Thank you for joining us. Well, let's see. Yes, we are too, if they would just get on it. Good Lord. Then again, there's probably a good reason for this, so. Let me see what Fox has got rolling. Same thing we do. While we're waiting, let me check something real fast here. Once I do this, it'll probably start right off. Don't worry, I'm not going nowhere. Nothing new. Yeah. Okay, so I don't see any new updates in regards to Jack and Lily Sullivan, guys, just to keep you on top of that. Nothing new there. Sadly. I wish to God something good would come from that. Thank you, SRB. Again, guys, with this up here, anybody that chooses to support our channel via any kind of donations, whether it be the Venmo, PayPal, Cash App, guys, that there itself goes directly towards us, our bills, the StreamYard, which is due right now, actually, the internet, and all the other fun little things that we need to run this show, super chats, super stickers, all that stuff comes to me the following month, and it's all very much appreciated, guys. We don't expect you guys to do any of that by any means, but it is so very much appreciated, and it helps to keep us moving day to day to day, and keeps me out here with you guys. So thank you to anybody that chooses to do that. We absolutely, truly appreciate you. Captain Jenks, welcome, brother. Good to see you. It is, Tracy. I absolutely agree with you very much. William Doyle, good morning and welcome. Good to have you here. Right, Cherry. There'd have to be filings to have him recused. And once again, just like with Delphi, when they tried to do that with Judge Gall, I have very little doubt that would happen. And they even took it. They'd have to take they took hers up to the Supreme Court and still got denied. So, excuse me. All right. Mysterious Minds. I really like that. Are you changing your... No, you didn't. You left it. Okay. I was gonna... Or did you change it? Your logo for your
channel. I left the heart.
It's the same? Okay. Because I like that a lot. It's really neat.
Too. And I worked really hard on it, so...
Yeah, you did a great job on it. Just as much as you did with the logo for this channel, the new red logo. Well, I love that, guys. You'll see if you go into the merch store, any of the stuff that Cassie's been putting together with the new red logo, it looks really good. Some t-shirts and hoodies and hats and stuff. The new coffee mug Cassie put together for the weird, creepy, unexplained Saturdays. Here we go.
Oh.
Defendant and counsel.
They're already talking.
Previously identified are present. We are in the session now.
I bet you they forgot to start the camera.
I have probably
my own agenda for what to cover today in the pre-trial motion, and so I'm not sure what you have. I didn't receive any specific motions.
There's Twiz in the back.
Other than, I think, the ones previously submitted by defense related to questioning of the jury. As I indicated, I don't intend to discuss in the public forum what specific questions would be asked of potential jurors, because I think that inhibits the ability to get frank and unprepared answers from potential jurors. And so we may have to cover part of that in a session at the end of the day. I think we can talk about it generally without discussing the specifics, but if we need to go there, that's what we will do. Apart from that issue, as what I intend to do is kind of break down the trial process through stages. And as you have issues or questions about whether how to handle something or how the court handles something, that's your opportunity to ask as it relates to that phase of the case. And we'll just sort of proceed in that fashion. So starting with some general issues, I just wanted, and a lot of this is unfortunately going to sound like me simply lecturing about what I want and don't want. And that certainly is a large part of it, because if you know what I expect, I think it makes your job easier. And so I particularly where I can't recall whether Ms. Massoth has had any trials with me or not, but I know she's been in front of me a few times, but the rest of you have not. And so it's, I think, important that you get that information straight from me rather than from the sources that you may get from asking around. So to start with, I'm not a fan of surprises, as you may have figured out by now. I want to know in advance, as far as possible, when there are issues that need to be addressed. That includes evidentiary issues. So if you know that you're going to object to some line of evidence, or you anticipate that there's going to be objections to a line of evidence, I don't want to wait until that is offered in the middle of trial for a couple of reasons. One, I don't have the opportunity to look at the issue to the degree that I would want to in order to give you the best ruling that I can. And two, it doesn't give you the opportunity to make the best case for me that you can for either excluding or overruling any objection. And perhaps even more important than all of that, from my perspective, is in what is already going to be an quite lengthy trial, it just extends it. And nothing frustrates jurors more than sitting around in the juror room doing nothing while we're in here doing something. And so that helps guard against that and minimize that amount of downtime that we may have. So we'll have periods, as I will explain to you, before court each day and after court each day, where if you are anticipating issues that are coming up, that's the time to talk about that, not in the middle of the trial itself. I did receive the parties' stipulation regarding how to handle the IGG tip, if you will. I'm fine with that proposed instruction, and so that will be given. I think I'd asked you also to work on an instruction related to the use of the terms surrounding touch DNA and other variations about that.
Thank you, Bemmy.
Meant that I decided to correct somebody about the use of that term. As I said, with respect to the professionals in the DNA community itself, I'm not going to prohibit it in the sense that, you know, I'm going to sustain an objection. What I would likely do is to clarify with the jury, if the parties want me to, about that being simply a convenient title and not meaning to imply an actual source of or method of the DNA being present. And so if you haven't worked on that, please do so to get me an instruction you both can live with. Otherwise, I'll end up drafting one myself, and perhaps neither of you want to live with it. So with respect to the model, I think referred to as the dollhouse by Mr. Thompson, has that been produced for the defense to inspect?
It has, Your Honor. It's actually here in this courthouse, has been for a few weeks, and Mr. Hurwitz facilitated the defense viewing it yesterday.
Okay.
It is available for the court's inspection well if the court would like to look at it. And just for the record, to the extent that the model was characterized as a dollhouse, I think that was an inappropriate characterization. It is an inappropriate characterization. If I'm responsible for it, I assume responsibility, but that's simply not an appropriate way for it to be described, given what occurred there and the victims.
I think a better term is simply a model,
Yes,
rough model, given that it is admittedly not to scale precisely. So, Ms. Taylor, any record about that? You had a chance to look at it?
Welcome, Samira.
We were able to bring 2 experts in for our request yesterday, and we appreciated being accommodated while we were here. We do have a remaining question about where the model house will be stored during the course of trial.
Where are you storing it, on the third floor?
Yes, sir.
Okay. So it sounds like it's stored with the evidence vault of the prosecutors down there. And so I suppose if she needs to get access, or our experts do, we can arrange for that as well.
I should have asked a better question, Your Honor. When it's brought in as a demonstrative aid, I am curious about when it's not being used by the prosecutor or the defense and a witness, where it will sit in the courtroom.
I will find some place not in the courtroom, because I don't want it in the courtroom when it's not being used, but nearby in the event that a witness does wish to use it.
Thank you, sir.
The other thing that I would point out, as it sounds like you've been, at least to some degree, working together, and I appreciate that. As you come to stipulations on agreement on things, it's important that those be reduced to writing for your own protection. Because too often what I see is in the middle of, for example, trial, well, Honor, the other side said that they were going to stipulate to that, and then they're not. That leaves me in a difficult position, because I wasn't part of those discussions, right? And so for your own protection, I think it's just important that you get those reduced to writing as much as possible. I did receive the parties' spreadsheets on the exhibits, which we'll go into a little more when we get to the exhibits portion of today's menu. But I appreciate getting that. There's some questions that I had about it generally, and then some more homework to do on it. In terms of the witnesses, I had asked, and I think my law clerk reached out to make sure that we get a description of those witnesses, kind of like if they're who they work for or where they're from, something that will allow me to categorize those on a juror questionnaire, so that they don't just get a list of 300 names, but can say, all right, these are witnesses, these people live in Pennsylvania. These are witnesses that work for the FBI, right? And so that they can put in context those names, which will be result in a more accurate review by them of those names, to see if they know anybody. And I'm not sure if that's been accomplished yet or not. And so if you haven't done that, please get that to us as soon as possible so we can incorporate those. I think the state had, and last I heard, but it's been several days, the defense we were still waiting for someone from the defense.
And I believe that that's been provided. My hope is that it was sufficient, because I think it came back and we re-provided it.
Okay, I'll check.
If it's not sufficient, let us know.
I'll check on a break to see where it's at. All right. So I did, as I indicated this morning, receive the defense's proffer regarding alternate perpetrators. That will be sealed per request, I'm assuming per stipulation. And I want some additional information there. What I'd like is by the 23rd, if possible, for the defense to do two things. One, provide me with whatever actual evidence you have that supports those allegations, rather than just allegations. And two, provide for me how it is you believe that what you are offering is admissible. Because it seemed to me much of what you had put in there was fairly potentially fairly objectionable in terms of admissibility. So I would like to see that. And then I would have the state respond by the 6th, which is 2 weeks. And then I would propose a hearing on the 18th.
Your Honor, on June 18th, Ms. Nassau has a conflict in the morning, but we could do an afternoon hearing on that day.
Can we do the 20th? The 19th is a holiday, and the court is closed. I'm just not sure whether it can be done in a half a day or in the afternoon or not, depending upon where we're at. That's my concern.
Your Honor, for me personally, the 20th is a little bit of an issue for personal reasons. If we could avoid that date, if we can't, then I guess we can't.
Well, let's. Can we start by like noon on the 18th?
12:30 or 1. I'm in federal court.
All right. Let's do 12:30. Are you handling those issues?
Alternate perpetrator. I'm, yes, very involved.
Let's do 12:30 on the 18th.
Was that June or July?
Well, I know they were talking about June 19th. So I'm not sure. And that's a holiday.
I thought he said, or Eddie said July 18th. Okay, I know he's cut. I'm trying to write it down. Thanks, Eddie. That way I have these dates in hand.
All right.
Everybody else is saying June.
Juror questionnaire discussion.
I hate to back it up, but
Before I do
I'll
that,
check it later.
This is a fairly,
There he is. Welcome, Sarge.
I want to ask you a few questions now because I suspect it will fit into, if you do a more specific category, you can address it at that point. But if you have a question
12:30.
or concern about anything we've talked about thus far, now's your chance. All right, juror questionnaires.
It's okay, Sass. What happened?
Huh?
What the hell happened?
I don't know.
It froze. Damn it. Come on. Sorry about the egg. It's froze now. I refreshed. It's still loading. Oh, come on, you guys. Let me check something here. Okay, so it's froze. It's froze on Fox's end too. So it's the court. Oh, come on now. Don't be doing this to us today. Fix your camera, Hitler.
Tomboy said it's June 18th at 12:30.
Yep. Thank you, Tomboy. I got that. That's what I thought. I just want to make sure I have it right. June 18th, 12:30. That's the only one they said, wasn't it? Yeah, it did freeze last time too. Wait, what did Eddie say here? 23rd deadline for providing evidence. She should be responded by the 6th. Yeah. Come on, Idaho. I refreshed it. It's still loading. They probably don't even know that it froze. Nor do they care, I'm sure, or at least him. Yeah, it's definitely not. Is it back on? I just refreshed it once.
I was gonna say I just pulled it up on the site and it's not froze.
It won't let me do it, damn it. Hold on. Try it again. Son of a bitch. All right. Sorry, guys.
So as I indicated, you'll be given access via shared drive. You can do two things. One, you could save those over to a copy over to a drive.
Amen, Sarge.
Edits, or you can print and make hand edits, or you can just keep track by notebook and juror number. If you want to do the printed version, you'll need to bring your own printer and supplies in order to print those off from your war rooms. The plan will be to take the universe of jurors who are summoned and then scramble them randomly and assign them what we call a scramble number, 1 through 10,000. And then we will bring them in to fill out the questionnaires beginning with 1. So that the questionnaires that you receive first will be the jurors most likely to be in the line of fire.
We have it back up, Tish.
Because once we have enough jurors, we'll stop. So,
great. Great live last night, Sarge. Great job, brother. Thank you for doing that.
No concerns, thank you.
Technically, under the rules, you are entitled to watch the scramble process, which literally involves the jury commissioner hitting a button. I don't know if any of you want to be there for that.
Well, thank you.
We'll waive our presence for that, Your Honor.
Very well. I do want to stress the security and confidentiality of the juror questionnaires, as I'm sure you're aware pursuant to Rule 23. Those are extraordinarily confidential. The copies that you receive will be, we'll maintain a copy, obviously, for appellate purposes. The copies you receive will be returned. The defendants, they're supposed to be essentially attorney's eyes only. I'm fine if you both agree to allow an investigator to see so that they can be doing, whatever online investigation they feel appropriate as you go along. Doing that, in terms of the defendant, his access has to be with attorneys present. In other words, he can't have a copy or whatever to go back with him when he's not with you.
That makes sense, but I have one question for the court. In addition to our investigators, we have 3 that are working on the case. We would request our paralegals be allowed to assist us just with the magnitude of the task. We'd like to have the assistance of our paralegals in organizing and reviewing.
Sure.
And likewise, Judge, we would hope to use our administrative assistants in the process, and they are part of our staff.
Sure, and by court and bar rules, you're responsible for their conduct, and so you'll need to make sure they understand the confidentiality of those questionnaires, and it's really your ticket on the line for their behavior. So that's fine. But I do want to stress that confidentiality because it is part of what I'm giving the jurors on the instructions is letting them know that there's a very limited number of eyes that will review this and that the public never will. So.
The link is in the chat, guys. If anybody wants to join Mama Bear and I up here, you're more than welcome to. If you're not one of the regulars, make sure to please show your face for a few seconds.
To try to process the first questionnaires. As I said, you'll get them each day and go through them. After 3 or 4 days, we will start to have hearings. Those will be sealed hearings because we'll be going over the questionnaires in detail, in which you folks identify the concerns you have with the questionnaire answers, specifically whether there's a motion or agreement to strike a particular juror before we ever have to bring them in based upon the questionnaire answer, right? And the idea is to dismiss those who are unlikely to be put on the jury because of either perceived bias, knowledge of the case, or hardship. And so, I think it helps everybody if we are trying to agree to that as much as possible. It's the reason that we are summoning as many people that we are, is so that we can really cut through the chaff and get to the wheat.
Hey, dude, you're not showing the stream.
Any questions about that?
I know. Hold on.
Okay.
Sorry. Sarge popped up here but fell out. Sorry, guys. I was trying to fix something. My apologies.
So
It's because I kicked him.
I have is for Dyer, more specifically. Traditionally, the way, as you know, voir dire works in Idaho is the court first does its voir dire, touching on some essentially statutory kinds of bias or knowledge. And then counsel is given that opportunity. And so much of what would be the court's voir dire, I have incorporated into the questionnaire so as to limit my role in actively questioning the jurors or potential jurors. I may follow up on some of the answers given on the questionnaires if I feel there's a need to. But otherwise, the time will be yours. What I intend to do, and I'll get your input on that, is using a model very similar to the model Judge Boyce and I came up with in the Daybell case, bringing in groups of anywhere from 15 to 20 people at a time, having a general session of questioning by the attorneys, approximately 30 minutes aside of those folks, get through challenges for cause or dismissals for hardship, et cetera, of those folks. And then who's ever left over of that group then would be subject to individual questioning by the attorneys. And so the jurors that are left over will be taken to, for example, the jury room and wait in there. And then we'll bring the jurors in one at a time to answer questions from counsel. The goal is, I'm not going to stop you if you're getting important information that needs to be got to. But the idea is after that more group discussion, the individual voir dire will be more for very sensitive topics, also for knowledge they have about the case from media or otherwise, because I don't want them to talk about it in front of other jurors. And then other topics that you sense were too sensitive to talk about in front of the others. Hopefully we can get through each of the individual jurors in 10 to 15 minutes apiece, but we'll play that by ear. We'll see.
Ask a question?
Sure.
So the 10 to 16 people in the general session, is that going to be the court's few questions and then each council has general questions? And just to make sure I understand, then whoever's left from there, we pull in and then we talk about case-specific information, the media items?
Media items, correct.
Okay. And would you envision that during the time we talk about media items, I can also find out their views on capital punishment?
Yeah, it may be that you are able to talk about that with the larger group to a degree. There may be some who appear sensitive to that and prefer to talk about it outside, and we kind of play it by ear. So it's not a subject I'm going to forbid from being discussed in front of the larger group. And you'll have limited time with the individual. So, you need to balance how you're going to use that time.
We may have to see how it plays out, Your Honor, but in my view, talking about the views on capital punishment is fine in a bigger group. My preference would be to be able to get the media items, people that aren't going to make it, to let them go before we do that. I think it would save time to have them gone before we do the capital punishment views. If we know they're not coming, they're not going to stay because of media coverage and those kind of beliefs and views, it makes more sense to have them go before we start talking about something else. My concern is the amount of time and that the media coverage items might find their way into a discussion of capital punishment.
Well, I will make it clear to the jurors that they're not to discuss anything they may have heard in the media during that general session. And we'll play it by ear. If it's not working, we can change it, right? So let's, and this is very similar to the way Judge Boyce had done it. I think it worked well. They got a jury fairly quickly. Now, as much as the attention was in that case, obviously this one seems to have more publicity. But I think that handling it with first going through the general, because we're going to lose people based on hardship, based on, have they made up their mind? Yes, right, kind of stuff. And so we don't even need to talk to them. And then we can get into the issues, or they may, simply give a view of capital punishment and that one that it's clear that they're not qualified either one side of the coin or the other. But if you want to deal more, if they're hedging or you're sensing some concerns, you can use that follow-up time in individual session to follow up on that rather than trying to do that in the public session. Any questions about that, just in terms of how the questioning will go? So my intent in terms of public access to the voir dire process is that during the group session, victims and defendants' family will be present. A small number of public seats will be available. And then it will be streamed to a larger room in the courthouse for anyone else in the public that wants to watch. It will not be broadcast outside of that closed circuit. Because then I lose control of the recording in the event that a juror's identity is revealed, and then I get all the internet sleuths out there trying to figure out who everybody is. And I want to protect the juror's privacy as much as possible in that regard. And so this does allow for a public access is the right, but also allows the court to tightly control that process. And then the individual voir dire will be counsel and the defendant only. And there'll be no stream.
Potential jurors' faces and names obviously won't be broadcast.
Correct. The faces will not be broadcast, and you are to only use their scrambled number as their identity throughout this. So they will never, you will never speak their name, nor will I or the court. It'll only be by that scramble number, and the camera view will not show their faces.
The juror number by which we'll name them. will that be on them, or does this court use paddles so that their numbers can be held up when we? want
They'll
to
have a
register?
laminated paper, like 8x10 paper that has cardstock laminated that has the number on it. And it'll be the scramble number, not their original reporting number. My goal is to try to get through 4 panels a day, which may not seem like it's much, but I know from the prior trial that they struggled to get 3 a day. So my goal is to try to get to 4 a day, but I want to get at least through 3 panel a day. The plan would be is once we get through the number of jurors we need to sit, including alternates and peremptory challenges, plus a few extra in the event something changes before the time we exercise the peremptory challenges. Once we get that number, let's say that number is 50, that's where we would stop and then go to the peremptory challenges. Does that make sense? Any questions about that?
Just to clarify that I understand it, we'll get enough people that we get 50 that have not been challenged for cause and then
That has been
exercise
passed for
peremptories.
cause, correct. So once you get that, if you will, struck panel, then we will exercise the peremptories. With respect to the number of jurors, prior to Friday, I had intended to use 6 alternates, and after Friday, I intend to use 8 alternates for a total of 20. That's about the maximum that I can fit into the jury box that we intend to use. So that number, 20 plus strikes, which would be 12 strikes apiece pursuant to rule, gets us to, I think, 44. And so the plan would be to get, 50 to 55 that have passed for cause to bring back for the peremptory challenges in the event that we lose somebody for some reason in between. Any questions about that process? Okay. So, and then when we're exercising the challenges, what I do is I give you a time limit geared to the number of peremptories that you have. So here, for example, you have 12 peremptories, give you each 30 minutes to exercise those. And it's a chess clock. So while the paper is with you, your clock is running. And once you hand it to the bailiff, it stops running and the other side starts running. Once you reach your 30 minutes, absent some showing of something happened outside your control, then your peremptories are over. Now, that's usually I give 1 minute per peremptory in the typical trial. I'm giving you far more than that here. It shouldn't take that much time, particularly with the number of people that you have keeping track of everything. If you both pass on a round, or let's say the defense passes at the end of round 4, and then the state passes at the beginning of round 5, that ends the use of peremptory challenges, because you both have said to me, by passing consecutively, there's nobody that you want to strike. So understand that rule as you go in. After the panel is selected, the jurors and the alternates, which the alternates won't be determined until deliberations, when by lottery, who's ever left will be determined to be the jurors, and the alternates, those who are drawn by lottery to be an alternate. But that group of jurors, and so the 20 will be taken to another location in the courthouse. I will briefly meet with them simply to introduce to them the people that will be talking to them, which will include the trial court administrator, the jury commissioner, and Judge Cawthon, who will be acting as it relates to this case as the administrative judge during the trial, to help them understand the process that we will use for juror security, for juror privacy, for reporting, and all of that, to answer any questions they have about that process so they know where to go to ask questions about the process, and sort of, if you will, onboarding them. Counsel won't be at that, nor will I, other than to introduce the people. And then I will leave so that I don't inadvertently hear anything that I shouldn't hear on my own. I want to stress the importance of no contact with the jurors in any way by you, your staff, your witnesses, anybody affiliated with the case. And so they need to be instructed as to that. So if the juror, if you happen to see a juror somewhere else in the courthouse or at the grocery store or at the coffee shop, you're not to even engage in pleasantries. Turn tail and run the other way as fast as you can. If you have any contact with the juror, you need to report it immediately to myself and to opposing counsel so we can then make any inquiry that we need to. I issued yesterday an order in this case regarding sort of the rules of the road for those attending the trial, as well as an administrative order that I imagine will be on the court's website here if it's not already, outlining some of that as it relates to
Morning, Be Real.
outside the courtroom. So my order in this case relates to the courtroom. The order, as I signed as administrative judge, relates to the courthouse at large. Make sure you have reviewed that and make sure your team understand that. There will be portions of the building that will be off limits to the public and to you. So make sure you understand that as well. I think I told you when you were here to look at the facilities, it's important that we know where it is you intend to stay as soon as possible, as well as any witnesses you put up, et cetera, so that to the extent that we ultimately may need to sequester jurors, which once it goes to deliberation, we will have to at a minimum, that we steer you away from whatever series of hotels that we've reserved as potentially available for us to use, that you're not there. So let staff know if you intend to stay at a hotel, if you intend to put witnesses up at a hotel, intend to have staff stay at a hotel. Let us know where that's going to be. You will each be assigned a conference room outside the courtroom, and you'll be given a key to it that you may lock each day, that nobody, including janitorial staff, will have access to, where you can keep your papers and files if you'd like, or other materials, and use to meet with witnesses, et cetera, as we go along. All right, before we turn to the trial itself, any questions about the jury selection process or the jurors?
No, sir.
No questions, thank you.
So the trial itself, the plan is to go from Monday through Friday with the session with the jury beginning at 8:45 each morning and ending at 3:30. Once we hit a sequestered phase, whether that be, for example, in a penalty phase or earlier in the case, should it become necessary, I will likely extend the hours of the trial to fill up the jurors' days. Part of the reason to give some time at the end of the day is so that they can do the errands of life that they need to do. But if we are hosting them, so to speak, we don't have to worry about that. And I'm sure they'd rather have their day taken up moving forward on the case. So that is the general plan. Counsel and the defendant dressed, ready to go at 8:15 each morning. From 8:15 to 8:45, if there are issues to discuss, that's when we will do them before trial starts. As I encouraged you when I first started this morning about this would be a really good time to discuss anything that you've just uncovered that might be an issue in the case. We will likewise have a period at the end of the day from 3:45 to 4:30-ish to similarly address issues that may be coming up the next day or in the near future. At this time, I do not intend to have trial on October 2nd and 3rd. Because of a previous commitment that I have. I talked to you before about potentially being gone on the 14th and 15th. As of now, I've been able to make alternate plans. So for now, you should plan on being here for trial on those days. Holidays that I could spot quickly on the calendar include September 1, October 13, and November 11. So those are holidays for which there would be no court, with the exception that if we are sequestered, we may have trial, and we'll address that as we go. Because I can't send jurors home for the holiday, and so we might as well use the time. Any questions about the trial schedule?
Morning, Kaylee.
Okay. All right, in terms of special needs that you may have for trial, I'm assuming there's no need for us to have interpreters for any witnesses. And then technology needs, be sure that you make sure whatever technology you intend to use works in the courtroom in which we will be. The best way to do that is to contact Ms. Barrios, the trial court administrator, and reserve a time to come down and try it out. I also suggest that you use on your team somebody that is far more technologically savvy than certainly I would have been in your shoes. Perhaps you are, but it's important to have your own IT kind of person there to deal with any issues that may come up. If you have litigation presentation software and it's not working, you might get a short recess of a few minutes to work it out. But if it's after that, we're just going to move forward and you'll have to figure out something else to use. So it would behoove you to have staff there that can deal with that. Likewise, in the event that something comes up last minute and there's a need to redact some portion of audio or video or other presentation, that you have somebody there that can do so quickly and knows how to do so quickly. And I would encourage you to plan ahead to have alternate versions of such things so that if there is a concern that's unresolved going into it, you have version A and version B you can use depending upon what the outcome of that may be. Any questions about technology? In terms of what we provide, it will be a overhead, what we call the Elmo device. which is the device where you set a piece of paper down and it projects onto the screen. And then we have a HDMI link for your computer to present whatever you want to from your computer. That's it. That's our technology. So anything beyond that, you'll have to bring. All right. Let's talk about seating in the courtroom, counsel table, and the trial broadcast. Each side, I think when we toured the courtroom, each side will have two counsel table kind of put together, which should give you, depending on how closely you want to sit together, anywhere from 4 to 5, maybe 6 seats at that table to use how you wish for yourself and your staff, and in the defense's case, the defendant. As I also indicated, I would provide a small table behind defense because they're not really as close to the bar as the state would be. A table behind you where you can have staff, 2 to 3 staff members. The state will have some room behind the bar, directly behind them for its staff. What I need from you are numbers. Understanding the space that you have in the well. How many seats do you need? Well, how many seats are you requesting and how many seats do you need are two perhaps different issues, but in terms of requesting, this does not include, for example, the victim's family or the defendant's family, but for staff. So apart from the 2 or 3 seats behind you, I'm assuming that's enough for you. For the state, likewise, 3 seats, 4 seats.
We should be able to make that work, Judge.
In terms of reserve seating for the victims, it will be for those statutory victims that was agreed to by the parties. And for the defense's family, it would be those 4 members that were identified in terms of reserve seating. What I would like to do, though, is I suspect that it's maybe that everybody won't be at trial every day. And so what I would like, excuse me, is for those that have reserved seating, in particular the victims, and I should point out I am going to reserve 2 seats for the 2 surviving roommates who are technically victims of the burglary. I don't know whether they would have any desire to be here. I suspect not, given the way they've been treated in the media, but if they do, that they would have seats available. But anybody who has reserved seats, I'm asking that they notify the trial court administrator what their plans are for each week. So if you tell me you're not going to tell the TCA, I would like to know, for example, we're not going to use 3 of the seats on Tuesday. So that we know, so that we can make those seats available for the lottery system, or it's not technically lottery, it's a first come system on a computerized basis. But if we don't hear from you and you haven't made arrangements, we will assume that you don't intend to be here. So it's important that each week you let the trial court administrator know. She'll give you an email address if you contact her, where you can send an email to tell us whether you'll need all of your seats or not that week, and at which days you won't. That goes for both the victim's family and the defendant's family. Right now, the plan is, and this is subject to change, to have a reserved seating, I don't want to say reserved seat, a seat selection process by which people can go to a website each day and at a certain time, and it's kind of like buying concert tickets, indicate a desire to have a seat, and the first X number that are available that get through will have a seat. It will be necessary to bring identification to show that you are who you are, or are who you say you are, to get into the courtroom. Again, that may be subject to change. I think the intent is for Judge Cawthon to have a town hall meeting with media in June at a date to be determined later to go over sort of what that process looks like, so that gets, so the media is aware, and so that then it gets publicized to the general public that would want to be here. My intent at this point is to allow a stream of the trial proceedings controlled by the court to be run on the court's, where, if anybody's watching today, where it would be today, on the court's broadcast page. The views will include counsel table, the podium, the witness stand, and the bench. There will be no production of the video, meaning there'll be no close-ups and zoom ins and zoom outs and things of that nature. It'll be the static views.
Before the court goes further, when we're talking about the reserved seating for families in the courtroom, if we have some other members of Mr. Koberger's family that travel and want to attend the trial, can we request an extra seat for a day for them?
Yeah, we probably be able to accommodate a few days here and there, but seating's going to be very limited, right? And so I don't want to extend that beyond the immediate family as a general rule, but if there's a specific day or two where there are going to be a couple other folks in town, talk to the trial court administrator and she'll see what she can do.
In addition to that, we have one other person on our team that would like to have sit with the victim or with Mr. Koberger's family. It's not somebody who would testify. So if we could have 5 seats, it's somebody who will just assist them, as the media might try to talk to them
Sure.
a lot.
All right. I don't have a problem with that. I'm assuming the victim witness coordinator will want to be there as well. So.
And Your Honor, as the court is aware, we have, unlike most cases, we have multiple victims here. So we will have multiple victim coordinators to work with separate families. We will coordinate that with Ms. Barrios' office to let her know.
Are you talking about one per family?
Hopefully not like that, but
Thank
we're going to
you.
need to split at least, we're going to need to have at least 2 separate groups.
All right, let's try to keep it as limited as we can, just because seats are at a premium. But
Yes, understood. Right. Your Honor, may I also ask the court in regard to the live stream from the witness stand? I believe that we've mentioned this, at least in passing in our trial brief. State anticipates that we may have witnesses who, for reasons the court articulated about the other 2 victims, surviving victims, that public live stream where their images could be captured and played games with in the media world. Is it possible for the video of that live stream when they testify to be shut off and just have the audio? We also may have a small number of law enforcement witnesses who also do covert work, and broadcasting their images publicly would be desirable. We will advise the court. We've asked the agencies to identify anybody in that capacity and to specify the basis, which we'll bring to the court. I just wanted to give Your Honor a heads up.
Your Honor,
Can we-
this is very high profile, and We've had people who have expressed reluctance to talk to us and being willing to testify for similar reasons. And I did have a chance to speak with the state this morning, and we agreed that what we'd do is take a look at our entire witness list and try to figure out people that might be more sensitive to having their video camera on their face while they testify. And we may approach the court with a stipulation for certain numbers of them.
Well, my intent would be with respect to victims, and I've already indicated, I think the two roommates are victims. There is a compelling interest to protect them. And so.
Welcome, Deidre.
Just as typically when media is present, they're not permitted to photograph or video victims that may be in the courtroom. If the victim requests it, their face will not be shown during the broadcast. In terms of those that work covert, I see where the parties land on that. If they weren't covert in this case, I'm not sure about that. I'll have to think about that, and you may have to convince me, because I think there is public interest at play here. And so we'll talk about it.
Thank you. Yes, sir.
And as for anyone else, you're going to have to really convince me because of the public's right and their hesitancy can be overborne with a subpoena. And that's what subpoenas are for. So I'm probably disinclined to do that in general for other witnesses. As you can see, I'm even hesitating with people that may have a line of work that is undercover if they weren't undercover in this case. So other folks who may be shy, probably I'm going to have to weigh heavily the public interest there.
I wonder if the same could be accomplished with a room where there could be a feed for certain bits of testimony to a larger group. I mean, it's still a public open courthouse, and live streaming something that gets captured for millions of viewers that lives on for a very long time might be different. And I can work with the state and then give the court a little bit more on that, but off the top of my head, that's what I'm thinking.
It's going to have to be a very compelling reason to do it. So aside from victims, while we are open in the sense that the people in the courtroom, the likelihood is we can't fit everybody in there that wants to be in there. And if I start not broadcasting the testimony, the full testimony of people who would otherwise prefer not to, that's going to fill up, it's going to be a large number quickly. And the best way that we have to ensure that the public is accepting of whatever verdict may be reached in this case is for the public to have the ability to see the evidence. So I'm not saying no, I'm just saying you're going to have to really convince me.
Thank you.
All right, any questions about either the seating or broadcasting besides what we've talked about?
No, sir.
All right, let's move to then opening statements. Let me start with what you've probably figured out by now. I am not tolerant of argument during opening statement. So if somebody is arguing and there is an objection, it will be sustained. Please don't do it. What I would like you to do is, by about the time that we're meeting again to select jurors, let me know what you estimate the time you need for your opening is. I will then look at that request and give you a time allotment based on consideration of that request. Each side will be given the same amount of time, and then I will hold you to it. In other words, if you tell me it's going to take an hour, I'm not going to tell you you only have 30 minutes, right? But if you tell me you want 5 hours, I might have some questions about that. But if you tell me you need an hour and I give both sides an hour, in about an hour, you're going to hear me say, counsel, you've got 5 minutes left. Use of exhibits or potential exhibits during opening statement. Because exhibits are not pre-admitted, even if stipulated to, there has to be an agreement to show the exhibit during the opening. Hopefully you both work together knowing what is coming in and isn't coming in, particularly where there's an agreement that something's coming in, other than spite, there's no good reason to not agree to it because the shoe will be on the other foot, so to speak, down the road. So courteous typically pays off with reciprocal courtesy. So work together on that. But technically, if it's not admitted, which nothing is by the time of opening, and there's an objection to using it, I would likely sustain it. For that reason, it's important that you, if you're going to use, for example, like a PowerPoint or something like that, that you share that with the other side at least 72 hours in advance so that they have a chance to review it and then work out any concerns they have and lodge any objections that can't be worked out with me, 48 hours in advance, so that I can then look at it and make a determination. If I haven't given you a ruling by that time and you're coming into openings without yet having a ruling, I suggest you have more than one version ready to go. One that is anticipates the objection being overruled and one that anticipates it being sustained. Let me reiterate again, please do not argue during opening statements or in voir dire, I should mention as well. Make a request at the beginning of your opening to enter the well and it will be granted. However, an invitation and permission to be in the well is not permission to invade the personal space of jurors. So understand that and stay a few feet back, at least from the bar of the jury well. If you are going to use a PowerPoint or some other presentation, you need to choose at the beginning of your presentation whether you want the lights on or off, and they will remain that way throughout your opening rather than turning them on and off again. So I suggest you do a dry run based on what the light looks like at that time to see what that looks like, to see if you want it on or off. Any questions about openings? All right. Next, I have witnesses. Before we do that, let's take a break. We'll take 10 minutes and I'll be back. All right.
All right.
All right.
Hold on. Holy fuck. That thing can't be played any louder, can it?
No, he doesn't. The mic is like away from his face and he doesn't lean in. It's ridiculous. I had to boost it. I even boosted it as loud as I could get it back through my settings. I'll double check it to make sure it's still up there. But in the beginning, to answer your question, is so all that stuff in the beginning, if there's anything else they have to discuss in regards to this, it comes after that. So There's a lot of BS with this. A lot of this stuff is pretty much normal shit, I believe, that goes on with just about any trial. So
I thought I saw Eddie up here.
He's in chat. He's not up here. Mama
Oh,
Bear's up here.
I'm sorry. Hello, Mama.
She was. She had to step out to help her daughter with something, but she's still up. She'll be back, she said.
No, the daughter has to come first.
Yeah, and Eddie and Jesse are both in here. They're both welcome if they would like to join us. The link.
Jesse's in here too.
Yeah, he was. Yeah.
Jesse needs to tell me just how he feels.
Okay, so I guess Wisdom said that Hitler had throat cancer, so that could be why his voice was like that too. It makes good sense.
Oh.
No problem, Eddie. Whenever you're ready, bud. A lot of this stuff is standard stuff. Now, I will say he has made it very evident from the beginning he doesn't like arguing. He doesn't like this. He doesn't like that. He does not want them to argue during opening statements or the voir dire, the jury selection process, and all that stuff, that he will sustain all objections and arguments, blah, blah, blah. I guess it's standard, but he's pretty picky. Welcome, Eddie. Good to see you, buddy.
I don't think he should be allowing Dylan and Bethany in the courtroom at all.
Yeah.
That's offensive to me.
I get it. How
are you going to argue the burglary without arguing other aspects of the case that they're going to try to tie to the murder?
I thought I heard that burglary charge was dropped at some point, but maybe I'm wrong.
No, there's still 5 charges on the kid.
The thing that he said that I disagree with is how he stated that they're victims of the burglary. Nothing was stolen.
I know.
That's ridiculous to me. I mean, that's just my opinion. Other people may disagree, and that's fine, but
no, that's the way it works in Idaho. I guess it's an automatic charge if you enter a house unlawfully.
Yes.
And it's considered a felony.
That's what they're victims of. Somebody went into their home. I get that to an extent, but with everything that Dylan and Bethany have done, I have issues with the way that they're being treated to an extent, I guess. That's just me.
No, I'm highly disturbed at how they've been treated.
Yeah.
It offends my sensibilities. Not that I'm sensible or anything, but if I had senses, if I was
you said that, not me. You said that.
Yeah. I know I did.
What's up, Eddie? How you doing this morning, buddy?
I just have a quick example of cognitive bias. So we were discussing, was it June or July 18th hearing? And for some reason, I just glanced at my computer date. It says 5:15 today, of course. So 23rd is the deadline for the defense to provide the court with evidence supporting allegations of the alternate perpetrators. And then the state must respond by the 6th. So in my mind, I added a month, fast forward a month from now.
Right.
And then the judge will propose a hearing for the 18th. So for whatever reason, my math wasn't mathing. I had it in my head that 5 is June. So you add another month to June, that makes July. It made sense to me. And of course, you're in a rush to get the answer thrown up there on chat. So that's what I did. And it's funny, once someone gets something in their head, it's hard to break them from that truth. Once I gave it enough thought, I realized my mistake, and Tomboy was right. And it was just
I thought he said it differently than that. I thought he said the 6th was for the defense to provide their stuff. The 23rd was for the prosecution to respond.
Yeah.
And then there would be a hearing. That's the order in which I understood it.
I just misheard the month. If I'm too loud, guys, let me know, by the way.
I suspect the 6th of June, Ann has to have her alternative suspects. By the 23rd, they have to respond to the prosecution. And then there'll be a hearing. I don't know when that hearing, I thought it was going to be in June, but you may be right that it's in July.
I thought it said June 18th too, but that's
I was wrong with the July. So it is the 23rd that would be this month.
Yeah.
I'm assuming he didn't see. Here's the thing. He didn't say the month. He just said by the 23rd.
Right.
If I recall.
He also mentioned the 6th.
That's what I was trying to keep up with my notes.
The 6th, yeah.
Well, the 6th was for the state's response.
Right.
Okay. All right. So I got that out. I get backwards, which is.
At any rate, cognitive bias. I had it locked in my head. It was July, and I would have argued it,
either way,
indefinitely. But that's
Not
how the
you.
mind works. So, transpose that in, practical application to this case. Think of how, if people have it that he's guilty, try to break them from that truth.
Yeah, you're not gonna.
Right. Agreed. No, we got the dates and everything right now, and Tomboy was right because the 19th was a holiday, and Ann couldn't do it on the 20th, so that made sense.
Now, Eddie, you are. Well, I know I'm probably a different type of streamer with the way I behave, but you're always welcome to come in the chat room or come up on the panel.
Well, thank you. Usually it's later than my hours, but I'll make it a point.
Oh, okay, I figured it probably was later because I try to do it around 9.
I'm sorry I missed that, Sarge. I didn't even realize you were going to do it. I wish you'd have given me a heads up earlier because I would have loved to have been there with you for that one.
And I wander off into the woods that I got nothing to do with true crime there, Eddie. So yeah.
No, you and I think alike on similar other subjects. I know that.
Yeah, so I don't have rails that I follow. I mean,
where you at, Jesse? Come on in here, buddy.
Yeah, where's Jesse? He went into my chat. He went into my stream and he goes, Sarge, tell us how you really feel.
Yeah, I knew you would too. It's a good show though. I caught it on the replay when I was sitting at the doctor's office. Good stuff. We were in here watching the Dateline thing finally last night. I finally gave in because I figured SRB made a good point. If we're going to talk about it and stuff like that, we probably should watch it and know exactly what the hell was said, even though it's a bunch of bullshit. It was still, we watched it. So
what did you take from it?
It's all garbage. It's I think every bit of it. And it was Tomboy said it herself too. I think the entire thing came out of Blooming Idiot's book, Bloomberg. Because
Blum.
Blum, whatever his name is.
Blum.
Idiot. He's a fool. But that's where it all seems to come from, and it's ridiculous.
Yeah.
They stated clear misinformation, and just it's nothing but pure propaganda. Fact. That's all it was. They lied about multiple things in there. They changed things again. So it's ridiculous. So
I'm disturbed with his interactions with women being just so normal.
That's the whole thing. And they've made this man out to be an incel in the very beginning, and he's absolutely not.
And suddenly he's got women trying to get with him. He's got another woman handing him her phone to put phone numbers in. I mean, here's Mr. Incel, the king of incels himself.
Yeah.
And then one of them rejects him and he doesn't have an issue with that. And then he rejects the other one in a way that's not objectionable.
Exactly.
Right? But What do you think, Eddie? Does that make him bad with women?
No, he doesn't hate women by any means whatsoever, like they've tried to portray him. He's not an incel by any means, like Willie said. Willie stated that's not Brian, guys. That's not who he was. He had girlfriends. He was attracted to girls. They were attracted to him. The girl, the Holly chick, like I said last night when I was talking to the mods in there, if those interviews would have been done before Brian was ever arrested, they would have never said those things. I can absolutely guarantee you that. But they had to, because they got to make him look bad.
If you play this in reverse and take what we now know and release it in the beginning, many people would have more questions about the case.
Absolutely.
And they wouldn't have solidified, like, what were you saying that was, Eddie? What did you call that when you came in?
Cognitive bias.
There you go. And that's really, I think, a big problem with so many folks. But if we would have known the events leading up to the phone call, the actions and behaviors of those that were involved in the phone call, if we would have known Brian's interactions with women, if we would have known more of this, where I think we really rightfully should have known early on, then it would have been almost impossible for the state to paint the picture around Brian that they painted. There would have been a lot of people going, that doesn't fit. He's an incel. He doesn't like women. So I really think that a misservice, and I think they do this clearly intentionally to win their case, regardless of truth or not.
I have kept reminding people that December 23rd was the first time that we have ever heard cognitive bias theory. And that was, of course, a full week before his arrest, put out there by Ashley Banfield of News Nation. And just think of that. How could that be? Unless, they knew, they being the ones who are in on this fix, that one of their hurdles that they're going to be up against is what would be a lone perpetrator's motive for this. And I mean, if you were part of a think tank, you and a group of people got together and tried to, okay, let's try to make that square peg go into the round hole. Let's brainstorm an idea that would hopefully sell as best as it can possibly sell as a theory. I mean, you're really limited. So your incel theory was established early in this case.
So was the idea that car is even involved in the crime?
Exactly.
There's no evidence to support that car's involvement. There's cars around the house, but
there wasn't that one though. It was in my opinion, it was the green one. That
in
car
the
had
beginning, he said all you need to know was written in the probable cause affidavit. We'll release that, and all the facts you need are right there. And he pushed that like he was trying to sell a vacuum cleaner to an old lady. Just kept hammering and hammering, you know.
They accomplished their goal. The PCA was a tool. They used it for exactly what they needed to, and they got what they needed out of it. That's why it's not relevant now. So
now they dropped that hot potato and they come up with a new theory. First it was 12, now it's 23 visits.
Right. They that's such a damn joke.
By the way, Daigle, thanks for having me up. And what I'm going to do is when it comes back from break, I'll hop off so my phone does, so I'm not just sitting up on panel.
Yeah,
without having, a purpose to be there, so to speak. So I'll just hop off and then the next break.
Yeah. And then once it's said and done, then we can have a full discussion on it, so on and so forth.
I'll probably continue to advertise my face. There may be someone in the audience that finds me attractive. As likely as it may sound, that could happen.
You're a mess. I love it.
My biggest concern listening to this so far has been there's no argument allowed during the opening statement.
That's a joke to me. That's a joke. But hey.
Well, you could object.
Yeah, but he's going to sustain it.
Yes.
They'll hear your.
I wonder if he's going to be capable to sustain the objection. If they start bringing, I don't know that it'll be that simple. And I'm surprised he's trying to lay it out. I think what he's trying to do is lay the most stringent guideline possible to try to avoid any problem.
Yeah.
But it's not going to work that way.
No.
Right?
There's still going to be arguments. I promise you there will be.
Yeah.
And like I said, it'll still be heard. It'll just be sustained via him. Regardless, you're still going to hear it. So,
yeah.
So be it. Sherry made a statement that she wonders who Anna was trying to hide via the witness list. I'm curious myself. If it's if it's an informant of sorts, and interesting. I don't think that, and he even said you're really gonna have to, other than the specific victims, as he said, really gonna have to convince him of hiding anybody on that witness stand. That's the one thing I have agreed with that he said so far, because the public's right to know, and that's, thank God that he has that thought. Is Hitler concerned about how the defendant is treated by the media? I highly doubt it. That's the one thing that irritated me, that he stated about how Dylan and Bethany have been treated by the media. Are you kidding me? They've been supported by the media.
They've been listening to my streams.
Yeah, must be. Yeah, they've been absolutely supported by the media and everybody else, except for a group of us. You know what I mean? So that was ridiculous. Absolutely ridiculous. But it is what it is. Nothing I can do about it. None of us can. Just have to deal with it. They're not, I don't see it. Here's what I've stated a long time ago. I don't believe they're not victims of this crime per se. In my opinion, they're victims per se of the circumstance of the crime. If you look at that and you feel that way, but I don't. So that's the only way I could see that, because I believe they were absolutely, they absolutely did everything wrong with that. Just for lack of better terms, I'll just say
wrong, offensively so.
Yeah, I'm being nice, Sarge. I'm being nice. So,
I know, but I mean, you can't witness someone laying on their back, head to the wall, feet towards the door, go to Bethany's room, and never ever recheck to see if the person's still in that same position. That doesn't make no sense.
No, it don't. Speaking of which, I'm gonna tell you guys something I did notice. Alicia SRB and I talked about it at the end. Miss Wisdom had dropped out, and a couple other people did. Through the entire Dateline thing, from the very beginning of this case, you guys remember that Maddie and Kaylee were the best of friends. They were very close.
Right.
They were very, very good friends, so on and so forth, right? Yeah, that's what we were taught. Well, Dateline completely flipped that and didn't even speak once about that. It was Ashlyn Couch and Maddie were best friends that grew up together, that were the bestest of friends. That was never once stated in Dateline about Kaylee whatsoever, and I thought that was quite interesting. That's crazy to me because that completely flip-flopped. Completely. They didn't even talk about Ashlyn Couch in the beginning of this. It was just Maddie and Kaylee, Maddie and Kaylee. Now they didn't even reference Kaylee. It was just Maddie and Ashlyn the whole time. I thought that was insane. Absolutely insane.
Dago, to bolster your point that you made a moment ago about them being victims,
Yeah,
I understand your point, but victims of what is the
that's what I'm
question?
saying. There is no victim, in my opinion. The only thing they could be possibly victims of is the circumstance of the crime. I still don't believe even that. I'm saying possibly, Eddie.
No, I wasn't. That wasn't a question for you. That was me beginning to say what I was going to
Well,
continue to
Oh,
say.
okay.
in all fairness to
Oh.
them, their home was invaded and 4 of their roommates were murdered,
That's
and
what I
that
mean.
does make you a victim.
To the circumstance.
Under
yes.
that, yeah, you're a victim to what happened. Your home was your
If they were
castle was
coached,
invaded. So
if that was a scripted 911 call and they were coached to do
Right.
that, then yeah,
There
they
is-
are victims,
yeah,
but not of like the court is wanting to have them be victims. They want what the state wants is for them to be victims of this lone boogeyman perpetrator, but
right.
that's not what they're victims of. They
Nope.
are victims, but of an entirely different thing that
The circumstance. That's why I keep saying that.
they're not going to say what they're victims of. They don't want you to know what they're truly victims of, just so long as you see them as victims of the
Yes, sir.
boogeyman.
Yep. Then that's why Wisdom just said that. Thank you for making that statement too, Wisdom. If they were victims, why were they both taken off the victims advocate list? Bingo. Okay, that should tell you everything you need to know right
well,
there.
they themselves could have requested it as well.
Either way,
Right.
they're not victims of that crime. They're not, in my opinion, victims of even the damn burglary, in my opinion, because they had the ability, because of what they did, in my opinion, to do things different. Therefore, I agree with Eddie. It's the circumstance of the moment within. Okay.
There's many people on this, and I got the air quotes, victims list. Like if Coroner Mabbitt was instructed to stay
Yeah.
on the script, this
Right.
is what you are allowed to say, nothing beyond. And so she did that. So is she a victim? Oh, absolutely, she's a victim, right?
Sure. Yeah.
Do you understand?
I do. Absolutely do. I do.
So and again, it's a long list of victims in this, in that way.
Yeah. Well,
The ones who are all on board, in other words.
if you want to go that direction, Bud, I'm going to say that you and I and Sarge and everybody else in here is a victim as well of the bullshit that has been spewed to us in that aspect. Yes. Not obviously a situation.
We voluntarily waded into it, though. I mean,
we did.
We did. With no waiter. We just went into the pond without asking. We just
we asked for it. Right. That's why I call it victims of circumstance. Be real, because it's the only way, in my opinion, to put it out there, Bud. You know, to make it make any kind of sense, it's ridiculous. So.
I can't wait to the trial. I want to know if there was any suspicion of a cleanup, and I think those girls need to be moved from victims to potential suspects and treated as such. I think that they should be included in the alternative suspect list. At least Dylan should be included in that.
At least Dylan, yes, sir. I agree with you. I still feel like Bethany could have been a pawn to an extent. We'll see how that plays out, but that's right. I definitely have my issues with Dylan. I'll be honest with you.
Yeah,
they even brought it up in the Dateline thing which I was amazed they did it. That they showed the whole thing with Brian, so on and so forth, and SRB or Alicia could probably correct me on this. Then they explained how when they showed her a picture of Brian, she said she had absolutely no idea who that was. That is amazing to me, and I'm glad they put that in there. So,
yeah, they definitely should be on the alternate perpetrator list if they are indeed. Like the defense in their investigation would know so much more about that. I mean, we're just on the outside looking in, and we're only able to obtain what may just be untrue facts in this thing.
Right. Well, we do got the documents from her interviews, and like I said a few times, the nose will set him free.
Yeah.
I mean, that's a very distinctive face.
Yes.
Even if it's covered in a mask, that nose, I'm telling you, he looks like fucking Rudolph.
That shit, and right. And I said she'd have been better off to acknowledge his nose than the eyebrows, because he doesn't.
And
even
then when
have
she gets a picture of him, she said, "I feel like it should have jumped off. It should have jumped that right off the page at me." But I can't remember that, or I can't.
You didn't recognize him because you didn't see him.
So I think that she's an exculpatory witness, irrespective of how everybody claims that she's a prosecutor. She may in fact be brought up by the prosecution, but her data is exculpatory.
I can agree. I think we're all on the same page with that one, Sarge, for sure. I won't be surprised. Sorry, buddy. I won't be surprised if Ann throws her name onto the alternate list, and I'll be happy to see that. Truly. Go ahead. Sorry, bud.
Just general question. Other than like the judges, he's kind of given general guidance or instructions right now. And other than that, beyond that, what do you guys think that
I believe the beginning of this is what that's all about, is all the instructionary stuff for the trial. And I think they'll hit on like the second half of the hearing. If I believe right, I think they'll hit on all the other stuff they need to discuss at that point, maybe after lunch per se, who knows?
Well, that's my question. What is specifically other stuff possible?
I would hope that the alternate suspect stuff may be brought into question. I would hope that they would I'd like to see them address the bullshit with the Gonzalez stuff.
He already just said that the alternate suspect perpetrators is going to be closed to the
Can I?
public.
Go ahead.
I want to just throw this out before I forget to say it. We have to separate our understanding of a crime scene to which 2 upstairs or 2 downstairs people were attacked independently and uniquely, and start to try to look that's possible. That did not happen at all that way. That these people were intermixed at some point in time, and that when you now know wounds are on Ethan's legs, you now know someone sat down in a chair with blood on her ass, right? How do you get blood on a right? So my point is, in my stream last night, it kind of dawned on me: this clean, crisp went upstairs, did his job, came downstairs, did his job, and walked out doesn't fit. Did he start downstairs first and go upstairs? Did he? I mean, we don't know. Is the point?
Well,
and it could be as crazy as all batshit for all.
If you go with the Dateline scenario, their interpretation now is that he came in, went directly upstairs, attacked Maddie and Kaylee.
Right.
Xana heard this, went up, running upstairs, and then she was chased back downstairs and attacked as she got to the door. And then somewhere in the mix there, Ethan was attacked as well. His legs were carved up, so on and so forth. But they were both attacked at the same time, simultaneously. So Brian ain't some kind of a super ninja. Nobody is to be able to do that. So if they're being killed at the same time, well, there's your alternate or the other suspect and or weapons involved. At least at the minimum right there. So I would like to see that brought into question. I would like to see that produced or spoke about at least.
I can't wait to see the technical information on the autopsies and the locations and manner of the wounds, because I think that itself is going to show a contradiction to this one knife, one guy theory.
Well, even if you go back, Sarge, I realized this the other day, Mabbitt herself claims it was a very large knife that did this. That's not a K-bar.
Well, she also claimed puncture wounds.
Right. And so did Steve. And I'm telling you guys, a K-bar knife is a 7-inch blade. It's not a very wide thing. And I still feel like this is much more plausible in that aspect. Something like this than a damn K-bar knife, okay? It sounds like it, at least to me. And it would make more sense because you have a reach. You can do things at a reach. And I've always thought that about that knife. I don't think the K-bar was the weapon of choice, in my opinion.
The fact that Ethan was taken down so quickly with one fatal stab wound tells me that the person that took down Ethan did it not only expeditiously, but as if they were trained.
Yes, military background, in my opinion. I agree.
Right? I mean, based on a little info they've given us on the condition of poor Ethan.
I do agree. It was very quick because they knew they had to get him out of the way. Period.
Yeah, one fatal wound to him, and then the other three apparently struggled. And I'm still curious about Dylan saying she came downstairs, went up the stairs, and came down the stairs again.
That would be supposedly Xana running up the stairs because she heard something and then being chased back downstairs.
No. Her statement was she heard Bethany come down the stairs, go up the stairs, and come down the stairs again. And Ann Taylor said, "We know that can't be true."
You mean Kaylee? Yeah.
Or yeah, I'm sorry, Kaylee. Yeah, you know me in names. So
I know. All right.
So that series of events is weird.
Down,
agreed. Up, down, right?
Maybe that happened twice. Then maybe Kaylee did come down and then
turned to run upstairs because the person came out of Xana's room and saw her and followed her.
Right.
That's plausible. Fair enough. That's what I mean. These whole 2.5 years, we've been trying to understand this as a systematically well-executed process of one room to the next, when it doesn't really sound that way now that you're hearing about the wounds that Ethan suffered, the blood prints on a chair from someone's ass cheeks, right? The pool of blood that Xana was in, and I'm sure, the other victims upstairs. It's more convoluted than the simple story. That just like the car being involved. That sounds so simple, yet it just doesn't fit.
Eddie, what was the June 18th hearing supposed to be for again, just to clarify that?
That will be when the judge proposed and I'm speculating here, he really wasn't labeling with anything, but that's going to be as a result of the defense putting on their evidence supporting the allegations of the alternate perpetrators, and then the state will have responded, to the defense,
right?
Having that evidence. So apparently, there's a hearing for that.
There you go, Cass. They weren't. They were. He was kind of hard to understand and hear everything. He's just the way he talked and stuff. So yeah, sorry guys. Yeah, I have extra questions now after seeing that thing last night. With certain other things now that are, and that's the funny thing, guys, is every time something new comes, they have completely changed. If you think about the very first day we saw this, the very first time we read the PCA, all of that stuff, nothing is exactly like it was at that point. Nothing. It's all completely different now, which is insane to me. Absolutely insane to me. From my understanding, Criminal Minds, when they said that his legs were carved, from the way it was explained to me, was that they were cut from the top of his back of his thigh straight down to the Achilles on both legs, like they were cut open. Okay, that's what my understanding was and it was explained to me when I asked about the word carved. So I don't know if that's fact or not fact, but that's how it was explained to me.
I'm thinking multiple leg wounds when they say carved.
I thought that too. But if that were the case,
go ahead.
If that were the case, that could explain the chair thing. Maybe he ended up sitting down trying to gather himself as he was fighting in this sense, per se. But then he ended up in the bed too. So it's kind of hard to understand this. But it does explain Xana laying in a pool of blood that wasn't seen by anybody during the 911 call, which is amazing to me. They didn't state that at all, that she's laying in a massive pool of blood that was stated by many people now. Why did they not say that on the 911 call at all? Or
when you walked into that downstairs room or that hallway, that blood would have seeped through them floors.
Well, that explains why it leaked down into that foundation on the outside side. Absolutely.
What a trap, man! That's horrible.
That could have been trying to cut the femoral artery, Yvonne. That would take him out right away. That does make sense, and it looks to me like he did bleed out. Both of them probably did with that much blood. Which again, we don't hear about that on the 911 call at all. Blows my mind. Not even one little bit. And I'm going to tell you right now, I do not believe probably anything she says. So when they claim that she runs past to go down to Bethany's room, glances over, sees Xana there, I'm telling you what I think happened. I think that she stopped, turned, because they kind of stated that in the Dateline episode that she saw Xana. They didn't say she caught a glimpse of her. I think she walked over to her, you guys, and tried to shake her to wake her up, and saw all the blood. Okay, because it says later that when she comes back up, she just starts bawling because Xana was passed out. Bullshit. You're not gonna bawl because your friend's passed out. You're gonna bawl because you know she's dead.
You know, when they say carved, I immediately think of a pumpkin. Did they carve something into him?
That's what I wonder.
Some type of symbol. I know you're saying that it was a slice from thigh to whatever, but that's a slice would be not referred to in my mind as a carve. They carved they carved into his legs. What was it? Was there some symbolism carved into his legs?
I wondered that too. By the way, Jesse, there's a link, buddy. If you want to join us up here, please do. But yeah, I wondered that right out of the gate, Sandra, if there was something specifically carved into him by, like, as part of the message.
Yeah, because that term is. What do you think about that term, Eddie? Doesn't it imply something specific when they say carved?
It to me, it does.
I think a lot of times, let's just call it like over dramatic. Like, okay, so there's an upcoming snow, right? We're gonna get weather. There's gonna be snow, and then you got this friend who's always, although he lives within a couple miles of you, you got a couple inches on your driveway of snow, and when you talk to him on the phone, he's it was just horrendous. Oh, drifts and can't get through and blizzard. It just you know how people over dramatize things.
Yeah, don't you think that's a unique term though? Carved to be specific into an action.
It is. It is.
Where if his legs were sliced, that would be referred to, I would think, as sliced. But again,
it'd be hard to read into it. Like, I mean,
I don't think I'm reading into it. I'm just taking the word for its literal understanding of carving, right?
Yeah.
People do it with something as benign as a snowfall, that they will.
No, you're right. You're right.
The little fish. How big of a fish did you catch?
And who mentioned carved? Was it Steve?
I couldn't even pull it into the boat.
Yeah, the boat sank because of the fish.
You see a picture of it. Well, it's a minnow.
I thought you forgot to put the plug in the boat and you had 14 beers before you took it out. No, it was the fish that sank that boat. You guys ever watch people launch boats? You got an area where you live where you could go down to the boat launch and watch people launch boats? Because it's so humorous to watch people try to back it up and try to put it in the water, and they often will forget to put the plug, because all boats, even the larger boats, they have a plug in the back to drain the engine compartment.
Total cluster, yeah.
They proved that was blood, Criminal Minds. That's already been verified. That was not paint, that was blood. And they explained how and why it was there a long, long time ago. The word carve, a definition would be a hard material in order to produce an object, design, or inscription.
Image. Yes, an inscription, an image, a design. You carve a duck out of a piece of wood. Right?
That's how it explains it. Or they explain it in a food realm, and I'm not going to go there because it would completely make everybody sick. So
I guess I would just, warn to consider its source. Like, are we supposed to think, is that supposed to draw out of us more of an emotion? Are we supposed to be like internally more mad at this Brian guy because he did such horrendous
it'll be nice. It'd be interesting to see if there's both blood of Xana and Ethan on the bed. My initial thought was, if it's not intentional carving, then she may have struggled and landed on top of his legs while the knife was being wielded after her.
See, when I first heard
the legs may look like carved wounds, but they may have been just either they went through her or they missed when they swung the knife and they were hitting his leg or legs.
Well, remember, the one thing they did proclaim many, many times is that there was a hell of a fight, an absolute fight that went on in that room with her.
Right. So we'll see when trial comes, and I don't think they're going to keep that from the public, are they? They better not.
I wouldn't believe so. I think it might be back or coming back right now, you guys. Here we go. All right. We'll see you in a few, Jess.
Witnesses not
Eddie.
watch the trial when they're outside of the courtroom, just like they couldn't inside of the courtroom. What I want to know is, with experts who are allowed to be in the courtroom, can those that are far away watch the live stream version if they can't make it to Idaho?
Mr. Thompson? Do you have any objection to that?
No, that seems to make sense, Your Honor. And I understood that the court was going to give an admonishment, acknowledgement from witnesses as they appear.
Bailiff, could you provide one of these to each side, please? This is an affidavit that each witness will have to sign, and you hand to me as they are going to the stand when you're called by them, specifically declaring that they have not watched the live stream. This is for witnesses who are excluded or otherwise consumed media about the testimony or evidence presented during the trial. That's not I'm not wed to the exact wording. So if you have wording suggestions, I certainly will listen to them, but that is the gist, is that they will provide such an affidavit each as they come to testify. Any concern with that?
Not with the wording at the moment. A question of clarification, though. If the case should reach a phase 2, does this admonition apply to those potential witnesses for phase 2?
So a witness who is only a phase 2 witness?
Only a phase 2. Yeah.
And they attend phase 1. Is that what you're asking?
If they watch or attend any part of phase 1.
Well, the problem with that is that phase 1 is also part of the state's phase 2 evidence, as is the defense's, right?
I think that would support the need for them to be able to know it if the state's going to rely on things that
Are you talking about experts?
Experts and possibly lay people too.
Oh, explain to me why lay people should be excluded from it.
I don't think they should be excluded.
So you think they should not be permitted to watch the trial?
I think I've got some double negatives going on. I think that if we get to a phase 2, I don't think that those witnesses have to be excluded from paying attention to phase 1. I think the protection for phase 1 is separate than phase 2 because of the rules of evidence that apply to any phase 2, the lack of them that apply to phase 2, and because the state's going to rely on what was in phase 1. So yes, experts and some potential lay witnesses as well.
Mr. Thompson or whoever wants to address this?
Our initial inclination is to leave that to the court's discretion. I think the whole purpose is to avoid prospective witnesses altering their testimony in some fashion based on what they've seen going on in court. That's the danger. I don't know why phase 2 witnesses should be treated any differently than phase 1 witnesses.
Well, what I'm going to do is, I'll give you a chance to each submit something within 7 days in writing on that, and I'll look at it so that you can give me any authority that you might come across related to that issue. Give me a chance to think about it further, and for the two of you to perhaps talk to see if you can understand specifically who you might be thinking of, to see if the state has a problem with that. All right. Counsel who calls a witness, unless it's clearly an adverse witness, in which case counsel needs to notify opposing counsel that they have not admonished that witness. But otherwise, counsel is responsible for ensuring witnesses are aware of orders in limine, otherwise clearly off a testimony that is off limits. Make sure they understand, the Rule 615 requirements and the fact that they're going to have to sign an affidavit subject to the penalties of perjury, that they have not watched this stuff. So it's your responsibility to make sure that they're aware, because when they don't comply, I'm going to be asking, why did you make them aware? While we were talking about the jury, I failed to give you the juror affirmation that will have to be signed by the jurors each day. Let me give you a copy of that along the same lines.
That's a good point, Lily. Oh, ow.
So that is an affidavit each juror will fill out daily, indicating that they have not violated the court's instruction or otherwise been exposed to testimony or information about the case outside of the trial itself. If I exclude evidence and you need to make an offer of proof, the opportunity to do that generally is when the jury, when we're not working with the jury, such as the morning session or the afternoon session, so that you can make that record as best as possible. So that can be done typically by simply making an oral reference to what the witness would have testified or what the evidence would have shown had it been admitted. Okay, let me. I think the rules are pretty clear, but some judges may have more leeway than others about objections. Let me explain to you what my expectations are regarding objections. So objections to questions or exhibits should be stated simply and without argument. It should not be a speaking objection. So for example, an objection, a proper objection might be, for example, objection hearsay. Objection foundation requires a little more. As you're probably aware, there's case law that is an insufficient objection. You have to identify what is missing from the foundation as part of your objection. If you think that doing so would put information in front of the jury that you're not certain I'm going to allow, please ask to approach. I tend to be a rather quick on rulings, on objections. I've been known to, testimony objection overruled, sustained immediately, without even giving you much of a chance to express your concern greater, because I can usually anticipate what the potential issue is and whether or not it's an issue. That said, if you think your ox has been gored and you need to address the issue more, either to have a record or in order to perhaps convince me that I'm maybe looking at it differently than what you anticipated or than I should, please just ask to approach, and then we can have a discussion here at the bench about that. If you need to make a further record for any reason on an objection or in response to an objection, simply ask to approach and we will have that discussion. I'm sure by the end of the trial, we'll have to replace the carpet from the trail leading from counsel to the bench, but that's fine. As I've shown you before, the court reporter will have a device like this that will allow her to hear through her earphones what we're saying. There will be white noise that's played in the courtroom so the jury and others cannot hear what we're talking about. There will be a physical barrier that blocks most of the view of the jury from what we're talking about at the bench that's rolled out so that they can't see. And we can have fairly fulsome whispered discussions here at the bench about that, whatever the issue may be. I have found in, doing this for far longer than I care to remember, that when I send the jury away to hear argument on an objection, what might take 3 minutes to have the argument on takes 12 to 15 minutes to get the jury back again. And then we lose a lot of time throughout the day that way. And so my preference is, as much as possible, to have those discussions here at the bench. Now, if it's a very significant issue that requires much more legroom, so to speak, to talk about it, then I will chase them out of the room, but I prefer not to handle the more routine stuff. One of the things about, I've had counsel before who confuse the idea of the need to make a record with the need to get my ruling and then offer a rebuttal to it. That is not making a record. That is making a rebuttal. And at least until it goes over to State Street, I get the last word and not you. And so I don't generally afford that opportunity. So if after I rule and you tell me you need to make a record, it truly needs to be a record on something that for some reason you were unable to make when you had the opportunity to do so, and not simply to see what my ruling is and then try to pick it apart. I will reiterate what I started with is I don't like surprises. If you anticipate an objection or you anticipate objecting to testimony you certainly know is coming, let's talk it over before the witness hits the stand, before the jury's in the box, so that I have as much time as possible to be prepared so I can give you as best a ruling as I can, and so that you can make as best an argument as you can. If you anticipate the potential impeachment of a witness by prior testimony, whether that's grand jury testimony, whether that is transcribed in witness interviews, whatever it might be, please get that to me before the witness hits the stand, and preferably towards the start of the trial, so that I have that available so I can have read it before the witness testifies, so that when you then ask to either impeach or to refresh recollection or whatever it might be, I will have read that testimony. Don't be mistaken in your belief that I have all that testimony. If it, for example, happened with Judge, I don't necessarily have all those transcripts, so get them to me. Or if I do, they're in one of 100 boxes somewhere back there.
Your Honor, if they've been supplied with exhibits and the purpose was just for that, will that be enough for the court, or should I have an extra transcript at the start of the day if I think I need it on paper for it?
So let me know as far as advancing possible, and I will have staff look for that. But otherwise, it's probably safest just to provide me an actual copy of it. But while I'm thinking of it, because I'm in my mind envisioning the materials from grand jury that we have here, the state did file a motion to get back its exhibits for use at trial. I assume there's no objection to that?
No objections.
All right. Mr. Thompson, if you may make arrangements with staff here to get those while you're here, okay?
Yes, sir.
I assume you have replacements you have or will get to me for those.
And actually, we had a procedural question we were going to ask the clerk. I'll ask Your Honor.
Clerk probably knows better than I do, but I'll go ahead and try.
We can do one of two things. We can either get together a set of photographs or copies of the exhibits and exchange those for the exhibits, or take the exhibits, document them, and then give the clerk what we've documented. We're happy to do it either way.
Well, my only fear is that you take the exhibit and then I don't know what the record is of what it actually looked like. Not to suggest that you would be involved in any chicanery and switching something out, but just trying as best I can to preserve that record.
Understood. So we probably will not pick them
Okay.
up on this trip, but we will make arrangements to have that done certainly well before trial.
Very well.
Thank you, sir.
Speaking of chicanery, I'm not fond, and you folks know that by now, of making accusations against opposing counsel that are not well-founded and supported by specific actual evidence. I know that you can get along, but I also know that over the course of a trial, particularly a long one, tension rises. And so I remind you of that to be professional. Don't talk to each other directly when we're in court, right? When the session's going, everything goes through the court as you know, the protocol with courts generally is. Refer to each other by professionally, Ms. Taylor, Mr. Thompson, not by first name while we're on the record. Again, avoid making accusations that you don't have the tickets for, or the receipts for, I should say. And under no circumstances should you make such accusations in front of the jury. It's a long trial, so as much as I want you to be prepared, you may have a local witness and a witness who's flown in that needs to get out again at the end of the day. And so it may be that we need to stop one witness's testimony to get the other witness in and then pick the other one up. As long as there's no clear prejudice from that, I'm generally flexible in allowing that so that we can accommodate that. And I ask you to both be accommodating to each other in that regard. All right, any questions about witnesses' testimony?
Just one, and kind of a takeoff of what the court just mentioned. We have at least one, maybe a couple law enforcement witnesses in particular who have testimony relevant to different stages of the case. And it's our intent, with the court's permission, to call them at different times instead of trying to figure out how to call them once and have them talk about what's going on at this stage of the case and then what may be happening next week with the case. Is that acceptable to the court?
Well, let's start with whether it's acceptable with Ms. Taylor.
Your Honor, I don't know that I have a strong objection or really any business in telling the state how to put on their case. That feels really cumbersome to me. I was hoping for leeway the other way when we would call a witness ourselves, but they're a state's witness. I'd hope to have a little leeway to do all of my examinations so they didn't have to come back. I would otherwise defer to the court.
Certainly, if you're somebody's on your witness list, if you want to go beyond the scope of direct as part of effectively your case in chief in advance, I don't have a problem with that. And so if it's going to save bringing another witness back, I don't have a problem with that. I don't have a problem if it doesn't get too cumbersome. If we're having a law enforcement talk about a broad area of one phase of the investigation at a time, that's probably okay. But, having them come up and narrate between every other witness is probably too much. Then the question becomes is how do we handle cross-examination? And basically I will defer to the defense on that or the other side on that to the extent that we allow, which is, do you want to cross-examine about the information they just presented now? Or do you want to wait until their last presentation and cross-examine about everything? And so that'll be up to you.
Your Honor, with that said, then I guess I'd request that the state let us know when they call a law enforcement that's for a limited purpose right now, but is coming back for another purpose.
Yeah, they need to let me know that as well.
Yes, Your Honor.
Hey, I just wanted to say thanks for having me up, Dago. I do got to fly.
No problem, Sarge. Thanks for joining us.
Responsibility to ensure that they're back at some point available to the defense so that they can cross-examine, even if you decide, oh, I don't need them anymore. You better not send them on an airplane somewhere where they're unattainable, because the remedy may be to strike all of their testimony as a starting point.
We would anticipate asking court and counsel if this witness may be excused if we're finished with them. And then I would give Ms. Taylor or other counsel an opportunity to let us know whether they still need that person.
Okay. Likewise, when you look at each other's witness lists, talk with each other and then write it in, get it in writing so we have it as to whether or not, for example, Ms. Taylor will need subpoenas to witnesses you have on your list that they want to also call, or if the other way around, you need subpoenas for their witnesses, or whether they will essentially agree to make them available. Anything else with respect to witnesses before I move to exhibits? Okay. All right. So I did require a meet and confer for you to go over exhibits, and I got those, and I appreciate the start that you have on those. There are a number of exhibits where there's appears to be, I can't tell. So for example, there's an objection to, for example, relevance or hearsay. Part of what I wanted to know, though, to start is, regardless of whether it's ultimately admissible for those reasons, is there an objection to authenticity? In other words, I want to make the trial go as quickly as possible, avoid the need to put on a bunch of witnesses simply to say, this is what this is, and they don't really have any substantive discussion about it. They're just authenticating a document that, if we were to be honest, there's no dispute that it is what it is. And so I may have you go back and look at that and add another column to the list, which is objections to authenticity. Now, some of the stuff, key actual evidence items, whether that's DNA or whatever it might be, obviously the defense is entitled to put the state to its burden with respect to chain of custody and all that. So I don't expect that. But on some of the other stuff, certainly to the extent that we can agree that if there's no good faith basis to contest the authenticity, then let's try to do that for everyone's sake. In that vein, I know the state had to withdraw its request to have certain documents self-authenticated to go back and do more work. Where are we at on that?
Ms. Jennings can speak to that, Your Honor.
Your Honor, I believe that we've submitted all of the certificates of authentication for all the exhibits we plan to introduce that way.
Okay. And you submitted those to the defense to review? Yes. And Ms. Taylor, are you going to respond to those?
Your Honor, we did. We met with the state last week, I believe, or the week before, and we discussed some of those records. There were some issues with them. Ms. Jennings provided me with a thumb drive, and I don't know if those have corrections on them, but I'll continue to let the state know. what we think, if we continue with an objection or if we're satisfied that the rule's been met.
Okay. If you could get with each other and then provide me I didn't study the exhibits that I got a day or two ago, or the spreadsheet that closely, but make sure I'm aware specifically of which exhibits there is no objection to the self-authenticating or otherwise not an objection to authenticity. Doesn't sound like we're going to need a hearing on that, at least for the time being, though.
Not that I'm aware of now, but certainly we'll keep our eye on it. I can alert the court, and if we can squeeze it into June 18th, that's possible. Maybe we
Sure.
can start that at noon.
Mm-hmm. Okay. And then I would certainly caution, at least because the state goes first for now, I'll say the state, that, belts and suspenders are good ideas when it comes to trial. So I would have my people I need to authenticate things under subpoena just in case. Especially if they're out-of-state witnesses, because that's not something you can do overnight. So the methods of displaying evidence to the jury, generally there's 3 ways to do that. One is by putting it on the Elmo and projecting the physical document, whether it's a writing or something else. The other is if it's a writing or something else, using litigation software of some kind to project it through the computer. And the third is passing it through the jury. That last one is the one I want to avoid as much as possible because that just takes too much time. So try to use the other 2 approaches as much as possible. Now, there are going to be some physical objects that it may be important for the jury to see, and I get that. But in general, photographs, things that are in writing.
Here we go again. Come on, Bubba. Stop freezing. Come on, damn it. Hold on. Let me go out and come back in. Sorry, guys. It's not me. Them.
Generally don't allow pre-admission because what I find is that I admit all these documents that then are never addressed during the course of the trial. And I don't want a bunch of exhibits to go back to the jury that they have no instructions on, that they've had no question and answer with a witness to explain what the relevance of those things are, so that they can just go back and use to justify whatever position they want to have from them. I think that's dangerous. And so the process, if there's a stipulated to exhibit, would be to, just as you normally would, identify it with the witness, or not even necessarily doing that. You're going to use exhibit 6, witnesses on the stand, and just say, Your Honor, I'd like to go over exhibit 6 with the witness. I understand that the defense has no objection to this. Look at you. That's correct. All right. Exhibit 6 is admitted. And then we go from there. On voluminous documents, if possible, try to avoid sending the whole thing back if there's only a small part of it that's relevant. If that's not possible, let's highlight the parts that are relevant and maybe even explain through the witness whether any of the rest of it is relevant, right? So that they know what to look at. In that same vein, if you have a voluminous exhibit and there are, say, 5 or 6 pages from it that are important, what I might suggest is the exhibit be, exhibit 47, and then you have 47A, 47B, 47C as marked exhibits. They go with 47, but they're separate exhibits so that the jury can keep those in mind, and we can keep track of those. It looks like from what I received, the state's using S dash number for its exhibits and the defense is just using numbers. Is that accurate?
It is.
Hopefully that won't get too confusing for people. Where we can, what I also suggest is that the defense is going to use as part of its case the same exhibit that the state has used and admitted. Let's not admit another copy of the same thing. Let's just use, so I like to say, the parties don't own the exhibits once they're admitted, the court does. And so there's no proprietary interest there. So if you already have it admitted in the form, just use that exhibit. Okay. I think my staff explained to you that in terms of submitting exhibits to the court in advance, if you would provide 2 copies of the exhibits in notebooks, so 1 copy in one set of notebooks and 1 copy in the other set of notebooks, and try not to make the notebooks bigger than about 1.5 inches each, at least on the copy you give to me, because it's just too unwieldy to use a 6-inch binder up here. Or if I need to take it home and read it overnight to do that. So try to keep it to about 1.5 inches per. And then for the actual exhibits that are going to be admitted, provide those first day of trial or whatever to the clerk in each exhibit in a manila folder with the exhibit number marked on the outside of the folder on the tab with the sticker attached inside the exhibit, so that she'll have a box of the proposed exhibits, the originals, and you can ask for exhibit X or whatever and she'll hand it to you to use. At least for the document exhibits and photograph exhibits. Physical object exhibits, work with the marshals on getting them in the courthouse. So for example, if it's something that's going to raise alarms at the security line, such as, I don't know, a knife, make sure you've got the aid of security in advance to get through that. The TCA can direct you to the marshal service and who to talk to there. We tend to use for dangerous items like guns and knives, a display box that the item would then be locked in to display to the jury. And so that can go to the jury without fear of an accident happening. I don't think there are any guns in this case, so I'm not as worried about that in terms of those being pointed at anyone by accident. But in terms of the knife, will probably be in a display case. If you're going to be using illustrative exhibits, give counsel notice of that as reasonably far in advance as possible for them to have a chance to look at those. Items for which chain of custody needs to be maintained until it's admitted. I'm going to leave that to the state to figure out where it's going to be stored and how it's going to be stored. Whether that's with a sister agency or whether you're going to have the sheriff up there bring down a trailer that can be locked up and kept at the sheriff's here property or something like that. However you want to do that, I'll let you worry about that. For physical objects, also provide color photographs so that we can have those in the record. At the end of the trial, we will likely give back physical objects to law enforcement to maintain. Depending on what it is, we'll see, and depending on what the outcome of the case is. But it's nice to have those color copies available for the record. Triple check all of your exhibits, particularly documents, audio and video, to ensure that there's nothing on there that is not supposed to be on there. Give audio and video to counsel far enough in advance they have the opportunity to determine whether they have an objection to anything in there, and you have the opportunity to either make redactions in accordance with the objection or to get a ruling from me about those redactions. What I don't want is the jury to be sitting in the back room while you all are making redactions at the last minute during the middle of trial. All right, for closings, kind of the same idea. I'll ask in advance for a time estimate, and then if it's reasonable, agree to it, but then hold you to it. A little bit more liberal, obviously on closing than in opening. If you're going to display things in closing, kind of the same light rule goes, which is lights on or lights off, so you'll have to choose. You can move about the well, but don't get in the juror's personal space. The state, when it gives me a time, I will keep track of that, and then for rebuttal, it'll be whatever you didn't use. So when you're giving me estimates, include your rebuttal in that. If you would like time reminders from the court throughout it, for example, if you're planning to keep 20 minutes for rebuttal, you can ask for a heads up at 30 minutes, something like that, when you have 30 minutes left, so just let me know in advance. All right, questions either about closings or about exhibits?
Your Honor, as to the defense exhibits, it would be helpful if they could be separated or at least delineated between which is for the penalty phase and the guilt phase, as the court will see when it looks at our spreadsheet of our responses to the defense exhibits. Some of them, we could see we wouldn't object to them in penalty phase, but we would in guilt phase, and they aren't clearly delineated at this point. If that's something that we could have addressed sooner than not, that would be very helpful.
Any problem with that, Ms. Taylor?
No problem. We did go over that when we met last week, and I identified which ones were for a phase 2 if we get there. I don't have a problem stating so, but we did make them aware.
Okay. Well, maybe if you can just put it in writing so that they have it, that'd be helpful. That way we don't have any misunderstanding between the two of you. Thank you. All right. Once you get and revise your spreadsheets based upon what we've talked about today, I'll start about part of what I'm going to do with the time that we have between now and trial is start going through all those, looking at what your objections are, getting my preliminary thoughts together on that. And then we may have another hearing just to kind of go over some of that if I have stuff that I think I can rule on in advance for you, or if I have questions, et cetera, but I'll let you know. All right. Anything else before I move on to jury instructions?
Not from us, Your Honor. Thank you.
As far as objections, Your Honor, the court has issued a number of decisions on motions and limine motions to dismiss. From the defendant's trial brief, the defendant indicates that he plans to raise those same objections again at trial. And it strikes the state that if that's going to happen, to preserve the record for no other reason, that should be done outside the presence of the jury, as opposed to interrupting testimony and presentation of evidence on matters that have already been ruled on by the court, if that is acceptable to the court and counsel.
So there's not a need to object again if I've already ruled on the objection. If you're asking me to reconsider, yeah, I think that's something you need to take up outside the presence of the jury, if that makes sense.
That does make sense. And on situations that may arise where we might want the court to reconsider, we'll definitely take that up outside the presence of the jury. I do want to make sure that things such as the model house that was the subject of a lot of objection, that there's a noted ongoing objection to it. I don't mind anticipating that and bringing that up before trial starts and outside the presence of the jury.
And to be fair, I only have what was proffered, right? And so I had a general proffer that the testimony will be that it, as I understand it, that it is consistent with the general layout, but not to scale, and that it would be helpful for the testimony. I don't have a problem with an objection based upon what that proffer is actually at the time. And so I think that's fine. I don't think that there's a need for an ongoing objection once that's done, but that helps.
Yes, sir. Thank you.
Jury instructions, I provided to you, I think yesterday, maybe pre-proof instructions. Did you get those?
I did not receive those.
Have we not sent those out? All right, I'll send those out probably today or Monday. They're not particularly, I think, controversial. They're pretty stock. On the pre-proof, in a capital case, there's a instruction. Normally what we instruct the jury is don't concern yourself with punishment, the subject of punishment. In a capital case, we are supposed to instruct them under 700B of the capital instructions in the pre-proof phase that it is a capital case, which obviously they're going to know through jury selection. So there's that instruction in there. And what I've done is we're also supposed to instruct them with 700C, which is, this is a capital case and you'll have to decide if you find the defendant guilty, what penalty to impose. But then 700C says, instruct them in a separate instruction, don't concern yourself with the subject of penalty or punishment in the guilt phase. I've combined those two things together. So take a look at that. I think it reads better than trying to do two separate, potentially contradictory instructions. I think it does it in a way that makes it more understandable. Other than that, they're very, very stock instructions. If there are other instructions that the parties want to be included in the pre-approved, for example, any stipulations that they want me to advise the jury of, let me know by submitting a request and copying my law clerk on that as well. I think you'll probably get before too long a set of post-proof instructions that are very loose in the sense that obviously I can't anticipate everything. It is based on what I sort of understand now. But it's helpful to have a discussion about that as early as possible so that we're all singing from the same hymnal in terms of what the likely instructions are going to be. And, for better or worse, as you know, the Supreme Court in last year, 2024, revised all their capital instructions. And so in light of that, I will be as much as possible sticking with what they have provided, given that it's clear they've obviously given it recent thought. And so I think that best insulates the case from perceived error by the court is by using instructions they've recently given us. My plan would be if there is a guilty verdict on the any of the counts of murder, would begin the penalty phase as soon thereafter as we can. Certainly probably the next day, unless it's, Friday morning when we get that, then we may not start till Monday or something. But given that the jury will certainly be sequestered during that process, the plan would be to go forward. I also will use as much time as I've told you throughout the day to get that accomplished as we can. If that happens and we are in a penalty phase, and there is a finding of aggravating circumstances, where then the court's discretion about which penalty to impose is pretty limited in terms of my discretion. In fact, i.e. none. It's either life without parole or death, right? In that case, I just want to get, before we get to that, defense's position on sentencing for the burglary charge, if they have concerns about sentencing at that time as well, given that it's probably not even a tail wag on the dog, let alone wagging the dog. So, but I'm not going to make you tell me that now, but I will ask you before the jury goes out what you want to do. I'm going to hand you another piece of paper that I would like to get back from the defense sometime in late June or early July, which is a declaration of last best offer. In other words, identifying whether the defendant received an offer and whether he has accepted, rejected, et cetera, just so that for purposes of post-conviction, we've documented that. Okay. Let the court reporter know whether you're going to want routinely daily transcripts or not. You don't have to tell her now, but.
Daily versus real time.
So there's two options. You can have none, both, or all, or either. One is I think we can set up real time where you get real time at your table for whatever the charge is from the court reporter for that. Also, there's the potential to get transcripts each day. I don't think those things are mutually exclusive. In other words, you could order both.
For separate fees if I want both.
Correct.
Yeah, make that decision.
Yes, not now. You may make that as we get close. And just contact the TCA and she will talk with the court reporters that will be assigned to this to make sure you understand what their structure is, fee structure.
Thank you.
And we obviously need to know, particularly about the real time in advance, so that we have the technology set up for it. And it may require you to bring some of your own technology in the form of a tablet or a laptop on which it's displayed, right? Because we don't supply the hardware, just the software and the actual reporting. Okay. My plan today, as we sit, is to get through the jury selection. I see where we're at with the intent that we not sequester to start. As I explained this morning, the more people talk to the media and the more things that are in the media that are not admissible, whether true or not, the more difficult it makes things. And so I'm going to have to figure that out as we get close. For now, intent is not to do that, but we will have plans in place to revert to that if we have to at any point during the trial. Do either of you want to make a record about sequestration at this point?
I would say the only record right now is that we understand what the court is saying during jury selection. If we still don't know if that could come up, the potential jurors should just be aware that it could come up prior.
It'll be part of the question that the questionnaire, as well as part of the hardship determination is there some reason they would be unable? I get that they wouldn't like to be, but would there be unable? Do they have a sick family member they care for or whatever, where they have to be home, right? So we'll talk to them about that. Anything from you, Counsel, Mr. Thompson, about that?
Not at this point. I understand the court might entertain some things in a closed environment later today, and we do have some sensitive issues to raise at that point.
Okay. That's my list of things. Did I miss anything, Giovanna, that you can think of? All right. That's my list of stuff, and I know this has been a very sort of nuts and bolts kind of lawyer discussion today, but that's generally the nature of pretrials when there aren't contested motions to discuss. And so that's my list. I'm happy to answer any questions about my preferences or how I handle things that I haven't talked about, or address anything else that you want to talk about. I know we do need to go to a closed session at some point to talk about what will be asked of the jury specifically. I need to avoid that getting out to potential jurors. So we'll do that in the closed session. But anything else in the public session we need to talk about?
I don't believe so, Your Honor. Thank you.
Your Honor, thank you.
Okay. Let me just look at my notes real quick before I dismiss the public, and we probably take a lunch break and then come back and take that up. I do have a copy. I told you there's a new administrative order. I'll give you a copy of that.
Me too, Rose.
Go dig for that. What's that? You've already given it to him? All right, perfect. Thank you.
Spare that we could have, Your Honor. That
Sure.
Oh, it's already at hand. Thank you.
I still don't understand why they don't focus the camera on Ann.
Yeah, actually, I have copies of the preliminary instructions for you.
Oh, thank you, sir.
In the closed session this morning, I indicated to you I'm going to be entering an order requiring the retention of records by the
That's
state.
what I meant.
I'm going to write another one extending that to the defense as it relates to violations of the non-dissemination order. I'm going to give you a copy of what that order is going to look like that I will execute likely over the lunch hour. It does require some action on your part, counsel. And as I indicated, I would be open to a request for a appointment of a special prosecutor, and that special prosecutor to ask for a magistrate inquiry so they have the power of subpoena and the power to question witnesses under oath, as well as the power to grant immunity. So I will be looking for that from you. And that one just deals with the state. I will get you one that deals with your side. to preserve records. All right. All right. Anything else? All right. Thank you. Why don't we come back in about an hour? All right.
Geez, y'all. That is not what I meant. I meant like they focus on the prosecution table and I don't want to look at Ashley Jennings. I'd like to be able to see like closer to the defense table, kind of to see what the mood is and stuff. That's all I'm saying. Like, I mean, I like her, yeah, but I ain't obsessed with her, guys. Jeez. Anyway,
Yeah, whatever.
I knew you were gonna say something. Anyway, special judge, special prosecutor. I thought they already brought in a special prosecutor. Don't you dare laugh at me.
I would never laugh at him. What the hell?
Welcome, Edward. Come back. Good to see you, sir. And the tomboy. Welcome back, guys. So agreed, Amor. That's my thing. I agree with that wholeheartedly. They seem to focus the camera, at least in my opinion, more towards the defense. I don't know if there's a reason for that. I don't know. Whatever. It doesn't matter. We don't need to look at her to know how great she is, in my opinion. No, I know that too, Wisdom. I know they don't want you focused on him, but they should still get a little bit closer to that area just as much as they do with the prosecution, I think. I'm definitely not a creepy stalker. Thank you. Oh, shut up. Shut it. So what's happening, Tomboy and Edward?
Is that
Eddie?
A votable question or statement?
No, it's not debatable at all.
Whatever.
So what are we thinking so far?
Oh, I have no comment.
I took a couple notes as we went along. So I think the first thing we should probably cover, there's been some confusion about the knife.
Yeah, I've seen a lot of people are going, that's not the murder weapon by any means. In case anybody doesn't realize that is not the murder weapon. There was a knife that was, I believe, found in his apartment, and then there was three found in his parents' home when they did that raid there.
Yeah, I want to cover the misconception about a knife being found in the apartment.
God, heaven forbid they find knives in a home.
So
go ahead, Eddie.
If we looked at the warrant return for 17 January 23, that was served in Washington for his Pullman apartment.
Yes.
I don't know if you have that anywhere.
I can pull it up.
Yeah.
Hold on.
It's not in the court record, but if you have it somewhere on screen, a reference to it. We did cover it.
Yeah, but that affidavit I didn't have in my files. Somebody had to give that to me at one point. Do you have that one, Tomboy? The warrant from Washington?
No, but I'm sure I can find it.
Okay. That's the one I struggled with, is when they pulled the warrant for that, because it's not in the regular court records that come, because it's in a different state.
That's when Don Daniels said, "Pay no attention to the
that chaotic, corrupted mess over there." Yes, agreed. Hello, Jacqueline. What the hell's going on with my phone? Hold on. I need to turn it off, I guess. Go ahead, Eddie. Explain that if you would like to. Unless you want to wait on the document. Hold on.
Yeah, I mean, we can take my word on it, but it's always best to, a picture is worth 1,000 words, and that way no one has to rely on another's say so.
Now, well, truly, my opinion, your notes are probably truer than the damn documents at this point. But anyway.
Well, I think it's important to, make sure we get this one straight, because if it's found in his apartment, the takeaway there would be more ominous,
of course,
than otherwise.
Yeah, of course, I agree with you.
And why should we we got to be really careful about where we're getting our facts and what we're saying and our discussion points and what we're talking about, because otherwise we're the source of misinformation out here. So
agreed. And there's too much of that already. So we don't need to be between Steve Gonsalves, Dateline, and everything else that's come out. There's too much of it as there is. So we don't need any more. I do agree.
Dago, could you check your Discord because you now have the Washington warrant?
Thank you, dear. Once again. My blue crew is amazing. Bingo. Thank you so much, Miss Tomboy. Let me blow it up a little bit for you guys to be able to see it and get to where Eddie wants me to be with it. And put my old man eyes on.
That ain't no lie. I'm going to shut up before I get in trouble.
Too late. Okay. Let's see. You just want me to read the whole thing? It's not.
No, it's just an itemized list. You should be able to just.
Okay, hold on. Right about. Hold on a minute. I know what you're talking about.
Yeah, there's like 49 pages.
I know. Okay, so here we go. The door's white swinging. Sees if located evidence of the above. Knife, sheaths, or other sharp tools, including. So they were asked to seize these things here. And the list of things that were seized. Probably at the very bottom.
Probably towards the bottom. Yeah, it's going to be an itemized list, numerical. Like number 1 would be a nitrile black glove, for example.
Yes, sir. Nitrile black glove. 1 minute. We're getting closer. Bingo. Here we go. All right. So number 1, 1 nitrate type black glove. Number 2, 1 Walmart receipt with 1 Dickies tag. 2 Marshall's receipts. A dust container from Abyssal Power Force vacuum. 8 possible hair strands. 1 fire stick with cord and plug. 1 possible animal hair strand. 1 possible hair. 1 possible hair. 1 possible hair. 1 possible hair strand. 1 computer tower. 1 collection of dark red spot collected without testing. 2 cuttings from an uncased pillow of reddish brown stain, larger stain tested. And 2 top and bottom of mattress cover packaged separately, both labeled C, multiple stains, 1 tested. There's no knife there, guys. No knife. So what people were getting confused with, I believe, is they seized 3 knives, I do believe, from the Pennsylvania house when they did the raid. 2 of them were labeled, 1 was indescript. So I think that might be where people are getting confused at when they swatted Brian and arrested him. So there's no knife here, guys. None.
And then I didn't watch all those interviews in their entirety. We did kind of go through them, segments or portions of them and cover them piecemeal in your channel, in your live stream, Dago. But so Karen, you said that, and I'm just trying to summarize what you said, but if I recall, Steve said that Brian Kohlberger has taken photographs with the knife in his hand.
That's what she claimed.
And I said, I haven't heard of that. Not challenging you on that, but
that was why I asked her.
If that's true,
that's the first time I heard that. Yeah.
Yeah, set me straight on that if that is true. But otherwise, we need, before just saying it, we'd need to know for sure, because otherwise, that's not very useful if it's not true.
Yeah, where'd you find it at, Karen, or where did you see it? I would love to see that, because once again, in my opinion, that would just be one more bout of ridiculousness that he spouted, and it's absolutely not true. But if it is true, I'm saying I'd like to see this where he said it. So I appreciate you putting that out there too.
Yeah, rather than saying someone said something, but if it could be specific, like it was the interview where he had the Clark Kent glasses on while he was talking to Ashley Banfield, for example. Specific, so we could refer to it and watch it and see it with our own eyes and know that it's
definitely am curious, because once
that
again,
there's a receipt, out there for it.
Yeah. because it's been multiple times that he's put out absolutely like wrong information, whether it's purposely done or not. He's doing it, and that's just all part of the let's keep this narrative going in that direction, in my opinion. So,
otherwise we get out into the weeds and we just, a lot of people on the chats, they say they heard something, and then it just kind of grows the life of its own.
Yeah,
so
agreed.
We got to,
well, he made a claim at just for instance example. There's a video of Brian going in the house. He said it one time, and it's like, what are you talking about? Like, there's not. Stop saying things like that. You know what I'm saying? You may be told that by somebody on YouTube, but it doesn't exist until there's proof of it. So, and he does that a lot. So once again,
not to belabor the point, but let's just put ourselves in Brian's position. Like, you're on trial for this, and someone is, misrecalling something, and it's harmful towards your case, right? It doesn't portray 100%. You in a very positive light.
Yeah,
you'd hope that you'd want that person to be more clear on their facts rather than just reciting something that isn't true about you.
Yes, and speaking of that, Eddie, Tomboy has a good point. I was going to ask you guys if you thought that as well, because that's what I took from what he said within his statements. It sounds like, and maybe because of the Steve Gonsalves World Tour, that he is going to be remarking the gag order to maybe slow that or stop that, possibly, hopefully. I could be wrong, but that's kind of what I was wondering as well, Tomboy. So I don't know if anybody else took that from what he had stated in that point.
Well, he
that
talked about the non-dissemination order, so that's kind of what
that's kind of what I was wondering too when I heard him say that stuff. And I hope it's because of that situation. Because it's caused between that and the Dateline cartoon, I'm gonna call it. There's been so much stuff flip-flopped and turned around, and it's just ridiculous. Number 5 from the warrant, Washington warrant. Oh, I see what you're saying. Okay. Yeah, that's interesting. Traced evidence including DNA from blood or skin cells or other source, footprints, hair, whether human. Oh, that's interesting, Tomboy.
Well, if on that paper that you just had up there,
yeah,
if you scroll back up to number 5, that's what it says. That it caught my eye as you were scrolling by.
No, that's a good point. Very good point. That would make, wow, that would be interesting. Hold on here. Let me go back up to the top. I ain't playing that all the way back up here. So, trace evidence including, now these things, by the way, you guys, on this warrant, so you see it, it says to NEPs.
It's what they're commanded to look for.
Yeah, right here. It says you are commanded to search within 10 days of this date the premises described as follows. Blah, 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 blah. And look for the door. Seize, if located, evidence of the above listed crimes, including number 5 says trace evidence, including DNA from blood or skin cells or other source, footprints, hair, whether human or animal, dog. Now, I'm going to tell you guys something. That's interesting because I had wondered. Realized that this warrant was served on this apartment the exact same day within, I believe it was a couple hours that Brian was arrested in PA. So, with everything else we've seen, I have very little doubt. And I told you guys, I don't trust. People disagree, and that's okay, guys. I don't trust the sheath at this point, and I haven't since I realized that they sent a swab to the lab rather than the sheath itself. So knowing that that statement was made and that was a command per se, and they were in the apartment with a swab, they could have swabbed anything, okay? Anything, in my opinion, and sent that off. And at that point, how is there proof that that was on that sheath? Explain that to me. Because nobody touched that sheath at the lab, in my opinion. They never sent it off. It was a swab. So that's when I started to doubt that when Eddie had stated that he didn't believe that that DNA was even on the sheath. That statement, when I looked into that at that point, made me start to go, okay, maybe not. I could be wrong, and I'm okay if I am. I'm just telling you, knowing that they sent a swab off to the lab as compared to sending off the actual piece of evidence. I said before, and I made it a little bit of a joke, but they could have swabbed his asshole, guys, for all we know at that point. Okay, we don't know. Is that what I would expect them to do? No, but is anything else that we've seen what I expect? No. They have all this other stuff that they confiscated from his apartment at that point. What are the odds? Okay, that's all I'm saying. And people, like I said, you guys can disagree with me. That's fine. I respect that. What's up, Matt? Good to see you. Miss Sherry, thank you guys for joining us. I'm just saying, trace evidence, including DNA from blood or skin cells or other sources, footprints, fingerprints, hair, whether human, animal, or dog. That's interesting. Very interesting. I want somebody to show me proof that DNA, I would have loved to have seen, which I know they won't. They don't have to show us. They don't. It doesn't matter what we think. But I would have loved to them show me the chain of custody on the sheath and show me how they got the process of this whole thing to prove that to me at this point. I know that sounds ridiculous, but that's truly where I'm at with this. Does anybody else up here have any feelings on that? Or anybody in general?
Well, the chain of custody is going to be key. It'll be interesting to hear that argument at trial.
Yeah, I agree. And yes, Siobhan, I agree. That should be something that should be testified to. I know it probably won't be, but it is, in my opinion, something that should be done. I want to know exactly when they found it. Yeah, that's another good point, too. Wasn't there a time constraint or a time lapse or something, Eddie, with that sheath? They claim in the document they found it at a specific time, but wasn't there a past, like an amount of time that passed, and then all of a sudden there it was?
It was on the body cam at like 12:04 and 54 seconds or something.
Okay. Right. The judge who signed the search warrant was concerned about trace DNA being the only evidence, too. Yes. And that they didn't even sign the search warrant. If you guys remember clearly that Dawn said it's a verbal signature. Whatever. That she called him, if I'm correct, while they were at the house or the apartment, if I'm right. And again, whoever can correct me, please. And they did it over the phone. Is that right or is that wrong? Anyone?
I was looking up more information about the sheath.
No, you're okay. Yeah,
because it's on one of our more recent documents in the case file.
Yeah. Matt says yes. SRB says yes. My question just was that the actual signature, the judge's signature on that warrant didn't exist. It was a verbal command over the phone that he okayed the warrant, and that's still a problem for me. They cut too many corners with this. Okay. Critical, good point. Even the corrupt cops in the Karen Reed case sent the actual evidence, not swabs. See, that's my biggest issue right now. That's why I struggle with this whole knife sheath thing, you guys. That's been the biggest thing. I had questions before that. And then when they released that information that it was a swab, I was done. I cashed it right there. I am not dumb, first off, and I'm not naive enough to believe that, sure, they swabbed the sheath and they sent it over. Why would they have to do that, considering everything else this case is presented to us? Looking at this document in itself, right here, the things that were commanded for them to receive, number 5 is one of the biggest things, okay? And now that we know, and it was admitted, SRB can, and so can Alicia, if you guys haven't seen Dateline, the FBI admitted, I'm sorry, not the FBI. It was admitted that the FBI lied and they used an unsanctioned database to run this. Heritage is what they used to do this. That was the big secret for a long time, but it was admitted to in the Dateline episode. So there, in turn, there's so many things that have been lied about, okay? Including that kind of stuff. That's important, folks. Bothers the hell out of me.
Okay, so your questions about the sheath. In the court record, other than what I just cited about the timestamp of the body cam when it was apparent, I think on the order on defendant's motion for Frank's hearing on page 8, somewhere on page 8, I have a note saying that Judge Hippler says Detective Payne discovered the knife sheath, and that's he's citing Exhibit D-14 from the grand jury.
That's not
And
even
then
true.
once discovered, Detective Payne notified ISP investigators, blah, 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 blah. And then also,
That's not even true. That's
we
wrong,
could,
Eddie. You know that, right?
yeah.
That's what I thought. That statement.
You went muted, Dago.
I think he is froze.
Frozen, yeah. Well, I'll just continue on. There's another. Are you back?
Nope.
No, okay. What I was going to say is also in the motion in limine number 6, we learned that the exact location of the sheath is unclear in both photographs. It's tucked under covers next to Miss Mogan.
Mm-hmm. I remember that.
So it seems by everything that we have access to that the defense still doesn't understand the true representation and how the state claims that they discovered this sheath. How do we get Daigle back?
Well, that's a good question. Let me.
Should we drop him the link?
Where's my phone? Let me see.
Well, he did mention that he didn't pay his StreamYard bill yet.
No, he's not online at all. He's not on Discord. All right, let me see if I can call him. I'll be right back.
Okay. Okay. Tomboy, are you still here?
Yes, I'm still here.
Okay. Well, let's ask chat. We're getting back to the knife. Steve, referring to Brian had a picture of it and he was showing off with it in a photograph or something.
She said she just found it on Fox 13.
Okay. Yeah, we need to take a look at that. In this second segment, before they went on a break for lunch, we learned what the lengthy pause was before they began the morning session.
Yeah.
It was a closed session that they had in the AM. Did everybody catch that?
Yeah, I caught that it had to do with the non-dissemination order.
Okay, good notes. I didn't pick up on what their purpose was. Who knows what they could have been.
Because he handed her, I think it's right, that's what he was talking about, but he handed her that paper. Did you see her slam that paper down? She is pissed.
Oh, I'd love to rewatch that. I didn't pick up on all the little nuance of, the happenings. But yeah, good catch. Yeah, unfortunately, this was, like Judge Hippler said, this is mostly nuts and bolts, and it was him having the floor and kind of just guiding the conversation along. So we really weren't able to witness much of a, back and forth.
Giving us our doo-doo list.
Yeah. The excitement leading up to it, I guess we could say, was more hopeful. We had more anticipation leading up to it than the actual experience of the hearing itself.
Let me go see on my phone if I can play that back, if I can rewind it. Hold on.
And thank you, Noel. Very kind and generous.
Noelle, if you're not careful, you're going to make Dago's eyes leak.
All right. You guys hear me?
We can hear.
Okay. Give him a few minutes. He's working on it. He said for whatever reason the internet dropped. He's gonna call him real quick and then let me know what's going on, if he's gonna be able to come back or not.
All right, chat or Mama Bear or Tomboy, throw out a topic and we'll discuss.
There you go. Oh my goodness, Noel, that's amazing. You're gonna make his eyes leak. Exactly what Tomboy said.
I know Ro was asking a question about the alternate perpetrator hearing on the 18th of June.
Mm-hmm.
Somewhere in that second segment, after that 10-minute break that they took, they were talking about, I think they were talking about exhibits, and was it exhibits? Let me refer to my notes real quick here.
I think so. I remember hearing about exhibits.
Oh yeah, it was exhibits. Anne still was like looking through them to see if there was any issues. After she had received the exhibit, she didn't have anything in mind at that moment, but she still was not complete with them. And I think the judge mentioned, well, as soon as you get them to me. And she said, well, maybe, we could add that to the June 18th hearing. So if that's like a hearing that's going to contain multiple discussion points, I guess my guess is I'm still of the belief that if they're going to be talking about alternate perpetrators, that portion of it would be sealed or closed to us. That's my best guess. Jesse, what's your question? Even if Hitler denies alternate perpetrators, she can still bring up circumstances that might point to other people. Yeah, that'd be a good discussion for.
Yeah, I'm not sure on that, and that's more of a legal.
Yeah, that's pretty deep. Maybe a couple people on panel trying to sort through that. It's pretty heavy.
Yeah, I don't know if Wisdom's in here.
Yeah.
Yvonne asked, I also thought the state wanted to pull back an exhibit.
Mama Bear, I'm going to send you something.
Okie dokie.
Yeah, I remember hearing some discussion on that, and I think that was even before this morning's hearing began, Yvonne. And that's according to the new document drop, which we haven't been able to go over together, all those new documents since they've dropped.
Yeah, Rose said she can hand a list and leave it open.
Yeah, so here's the document. It's the May 13th, state's motion to seal Exhibit S1 to state's motion to reclaim exhibits. I haven't even read any of these documents myself. Yeah, there wasn't a lot of, I don't know, it would take like a recap, trying to go through all these discussion points this morning in this hearing by memory would probably just, it'd be like a, just cursory glance over them. But like I said, I made a few notes as we went along. One of them was interesting about, no contact. He's going to be very strict about no contact with jury members. If they're out and about at the grocery store, make sure you turn tail and run. I found that was interesting. Like, why they're going to be out and about at the grocery store?
But Tomboy, is it towards the beginning or end? Because the
It
29.
actually should have came up right at the exact time.
Okay, hold on. Let me go back.
I thought he said only sequestered if there's deliberation.
No, I think I just generally feel like sometimes what he says, it just needs translation for me. Someone needs to step in as a translator so I can understand it better with him. Or maybe it's just because he kind of lulls me to sleep with his his manner of speaking.
Oh boy. Hold on. I wonder if this is gonna work. Because I am not on my own. I'm actually on his panel. Should I share screen? It's gonna work. Let's try. Yeah, he would have to pop it up there. So I assume you guys cannot see that. Correct. Yep, it's not gonna work. Okay, he just texted me and said that he apologizes, but he is not going to be able to come back.
He'll have to shut down the stream, and then we'll have to get on a different live stream of his if he's gonna.
Yeah, his internet's down, so he's not going to be able to come back at all.
He won't be able to come back at all.
Yeah. Okay. So he said he didn't know what's going on, but he sends his apologies, and he's very upset and very frustrated at this. So.
Okay.
Maybe I can. I don't know if I can talk to him and figure something out with maybe my channel and have him come up. Maybe I don't know. Let him use my channel. I don't know. I'll just have to talk to him. I'm not sure, guys. I'm sorry. His internet service is the worst. It really is. So I want to thank everybody for being here and supporting him and everything. Us. I guess that's it.
Does he want to give it one more college try, or does he give us guidance? What's his guidance? Should we just drop off right now and end it?
I think just drop off now and end it the way he's talking.
Sure. Okay. Well, I think we covered most of the highlights anyway from the hearing.
Yeah.
But okay, I'll jump off now. Thanks for having me up as always.
All right. Yes, of course. Anytime, Eddie.
And we'll talk to you all soon.
Hopefully soon.
Bye.
Bye, guys. Have
Bye,
a great
Tomboy.
night. We'll see you soon.